Writ petition has been allowed. Yes, Mr. Malik.
My lord, this eviction matter, there is separation of eviction. Lord, may kindly, we have filed it is on 20th, not at this. It may list the kindly remote.
Motion matter.
Motion.
My simple permanent motion matter matter
Tomorrow, yes, all motions tomorrow allowed.
May I please the lordship with the consent of the other side, I beg to mention item number 23 for adjournment.
23.
Yes.
Yes.
I have appeared matter for respondent. Date may be fixed, it may be fixed on 31st July matter.
17 matter. Oh, this matter. Okay. Oh. This is for hearing.
Yes, yes, ma'am.
A request has been made by Ms. T. Goswami, Learned Counsel, appearing for the respondent AFC for adjournment. Put stop.
The petition I have prayed for. I'm praying.
Oh, you have, okay.
Petition.
Then a request has been made on behalf of the petitioner for adjournment. Full stop. Ms. T. Goswami, Learned Counsel, is present for the respondent corporation. Full stop. Considering that this writ petition is of the year 2017, a slight accommodation is granted and the matter is directed to be listed for hearing on
31st.
31st.
I thought I said.
As requested, list for hearing on 31 July. Slight adjournment. Yes.
May I please the lordship?
For hearing, huh? Into. Yes.
Lordship, I beg to mention a request for listing. May kindly be listed on
Listing for what?
property dispute.
What is the stage? Motion we have allowed all, everything. No need to mention.
Friday.
Motion, all my motions allowed, whenever.
Please, the Lord. My lord, item number 11, my lord,
Hmm.
the motion matter. My lord, this matter, the prayer which we have prayed for has already been provided to us.
Okay.
That you can-
Okay. Sri K. Muhammad, Learned Counsel for the petitioner, has submitted that after filing of the writ petition, the grievance of the petitioner has been redressed.
Yes.
Anyone has appeared for Central Bank of India?
The
CBI? Central Bank of India. Is anyone appearing?
already-
Mr. Sharma, you are for CBI.
Yes,
He is withdrawing this.
yes, sir.
Sri M. Sharma, Learned Standing Counsel CBI is present. Para, in view of the aforesaid submission, writ petition is closed on withdrawal. Yes.
Apply.
May I please, lordship? I beg to mention item number 15 with consent of the other side.
Yes.
Lordship, respondent number 2, 3, and 4 has filed an affidavit of opposition.
When?
Lordship, May 2025.
Hmm.
22nd May 2025. We are preparing a affidavit in reply, my lord. Today itself
16
we filed.
matter.
Lordship,
16.
they filed their opposition, my lord, only 22nd May of this year, my lord.
Today is what?
Lordship,
Today is what? 23rd of May.
today,
Is it 23rd of May? Just yesterday it was filed. It has been filed 1 month ago.
Lordship, I'm filing our response today itself.
Okay. Ms. P. Bora, Learned Counsel for the petitioner, has submitted that the affidavit in opposition by respondent numbers,
3, 4, and 2, 3, and 4.
by the official respondents,
Sure.
has been filed recently, and a rejoinder affidavit would be filed during the course of the
Okay.
day. Para, list for admission hearing immediately after the vacation,
Sure.
along with the affidavit
Sure.
in reply, which may be filed.
There is an interim order that may be.
Para, interim order, and list immediately after vacation, or list on, to say the date, list on 17th of July. Huh? The interim order passed earlier to continue till the next date of listing.
Obliged.
Yeah, please, Lord. Lordship. Item number 17, my lord. Matter become-
Item number
17, my lord.
Yes.
The matter become instruct.
Sri A. Mubarak, Learned Counsel for the petitioner, has submitted that he has instructions not to press this petition as it has become infructuous. Anyone, Barpujari is there in the court? Sri R. Borpuje, learned counsel for the respondent. Number 1 is present. Para. Petition is accordingly dismissed and closed. The petition is accordingly dismissed. Is accordingly
Sure.
closed. 17th. Read no to contempt petition. Petition co op. Yes.
May it please your lord. I beg to mention a matter for unlisted today
Unlisted. Why?
because of the certain reasoning. What has happened, this is the matter with regard, earlier there was an order by this honorable court to do a demarcation of a particular plot of land, and which was to be done as per the court's order and as per law. Now what they have done, they have given a notice day before yesterday, without even, there was undated notice, and fixing it tomorrow for demarcation without following the initial procedure which is required to be done. But just for that reason, your lordship, I have come as a prayer for unlisted. At 2 if possible, we have filed the
Okay.
Lord.
Bring it at 2 o'clock.
May please, your, I beg to mention item number 25 with the consent of the other side,
2-5.
to 25.
Yes.
Maybe passed over for the day. I'm respondent number 4. Mr. S. Borua is not available today.
20.
25.
You're for R4.
Our respondent number.
Your name is not there in the cause list.
Mr. S. Borua is now the counsel for pollution control board.
Oh, PCB is a party here.
Yes,
Okay. Have you informed the other side?
yes, dear.
This is a motion, a hearing matter of 2018. Okay. On a request made on behalf of Sri S. Borua, Standing Council, PCB, a Pollution Control Board. The matter is adjourned and is to be listed on 17th of July for hearing.
What the-
May I please, my lord, with respect to item number 9, my lord, our
Hmm.
department instructions are awaited, my lord. May I pray
9.
for listing this matter after the vacation, my lord.
Taken the consent.
My lord, we have taken the consent.
Okay.
Your lordship, there is an interim.
Sri H. Barua, learned counsel representing the department, has submitted that. No, this is for motion. Will issue notice. Will issue notice. A short notice. Okay.
My lord,
Yes.
First of all, recommend for listing of a read petition. It was last.
For motion,
No lordship, admission.
admission, this, what is the urgency?
After vacation any day.
After vacation, you put a date. Okay.
Okay.
I would like to mention item number 16, that is infractions matter.
16.
Item number 16, which is regarding construction of a
BTC, anybody from BTC is there in the court? BTC?
The construction part is over already, my lord, during the pendency of this matter.
Anyone
Construction of-
from BTC? Please inform. Madam Bormon, BTC. Who's there? SR Abhay is there or B Chaudhary? Oh,
BTC like Rabha only, Rabha.
Sri
Or
J.
the-
Sharma, learned counsel for the petitioners has submitted that by a flux of time, the matter has become infructuous. Also heard Sri SR Rabha, learned standing counsel BTC Para. Petition is accordingly dismissed as infructuous.
Okay.
Yes.
Item 28 for withdrawal.
Sri R. Mazumdar, learned counsel for the petitioner submits that he has instructions not to press this writ petition. Also heard Sri N. Das, learned state counsel, as well as Miss H.G. Barua, learned counsel for the respondent number 7. Para. Petition is accordingly dismissed on withdrawal. Yes.
Acknowledgement.
Is there any interim order?
No.
Item 1.
Lordship, the petitioner absent though, but my lord may kindly dismiss this petition because there is a PIL of 33,010. There is a direction from this of this court, done peaceful by the respondent. That lordship will find it paragraph 18, my lord.
No, what was the order passed on the last occasion, 29/11/2024?
They are lingering this matter, they are delaying the direction of the.
Where is where is Mr. Chaudhary, who is assisting?
Chaudhary sir is appearing in this matter, my lord. That's why the honorable court not issued the notice yet, my lord. Because I have informed this honorable court that there is a division based order of this honorable court to do the needful, and we are directing to do the needful, and they are trying to delay in the process. In fact, the order was passed in the year 2016. और उसमें खाली timing ना matter.
No, can anybody have call Mr. Chaudhary or any of his colleague? For the resolution, have been elected for the society. I think none appears for the petitioner on call, whereas Miss MD. Code number?
It'll be in item number 12 also will be appearing.
Okay,
And
we'll.
Nani is appearing.
Huh?
But
Nani is
Nani is
appearing.
just
We'll close this, let him come, okay, in a while. Because the submission which was recorded on 29/11/2024 also gives the impression that there is nothing to be adjudicated
Yes,
now.
my lord.
They have been elected.
Yes, sir. They're trying to delay the process,
Okay.
lordship. Only
Oh.
the one direction, the name of
Okay,
Wait,
there will be no more
wait.
delay to let him come.
lordship, keep your place.
Item 2.
Read petition to judgment to allowable question hai? ठीक है sir. Yes.
May I please the lordship? Matters regarding lordship, the petitioner's husband taken some loan lordship. The bank is now, and in the meantime, he expired and the bank is asking the petitioner to pay.
What is your role in the transaction? You are a guarantor.
No, lordship, I'm the wife of the deceased.
No, what is your role? Wife is okay. What is your connection with yes, Mr.
Your
Soni?
lordship, instructions is pending. But
24 matter, why
but
instructions are pending?
loan has been confirmed and we have put on lien to the loan account. And on the
There was
last
a lien.
occasion, one
No,
advocate-
what is her connection with the loan?
Your lordship, she is the, I think, legal hire, your lordship.
No, does it bind the legal heir?
Yes, your lordship, because the account belongs to the husband.
No, understood. Does it bind? Is the agreement in such a way that it binds the legal heir?
Your lordship, just one big thing.
24 matter, we issue notice at this stage. Heard Miss S. Kanungo, learned counsel for the petitioner. First of it is the case of the petitioner that her deceased husband, who was a head teacher of an LP school in the district of Nalbari, had availed of a loan of rupees 16,90,000 from the Central Bank of India, Belkhor BELSOR branch. The husband of the petitioner had died on 27/6/2024, and the grievance of the petitioner is the action of the respondent bank in trying to recover the amount from her. What is the illegality, madam?
And otherwise, as the legal hire, she is like.
But 1 year it is pending. Okay, let notice be issued. Returnable by 6 weeks. 3 M. Sharma, Learned Standing Counsel, Central Bank of India, accepts notice on behalf of all the respondents.
All the respondents.
Let extra copies be served upon him
One, two.
within 2 days. Okay. File your returns, we'll see.
Yes, sir.
Deep blue pen.
3.
May it please your lordship. Lordship pursuant to the final order dated 16/5/2018 and lordship final order dated 29/4/2020, lordship, we have filed this contempt petition. But lordship, earlier to this contempt petition, we have filed a same contempt petition in the year of 2023, lordship. But lordship, we have withdrawn that earlier contempt petition, which had liberty to file a fresh lordship on 26/4/2024. So lordship, this is the fresh contempt petition we have filed.
Against which order?
Lordship, a final order dated 16/5/2018.
What about the limitation, madam?
Yes, Lordship, but Lordship, the earlier contribution we have filed in time, but Lordship, as at that time, Hosai district was not in effect, Lordship. So we have made a party to the Deputy Commissioner of Nagaon district.
So you could have continued with the earlier petition. Imply the party.
But Lordship, with a notification dated 22/9/2024 and 21/10/2024, Lordship, the Hosai district was still again restored, Lordship.
You cannot file a fresh petition. The earlier petition proceeding would have continued. This is a fresh cause of action you are trying to now make in 2025 for an order passed in 18 and one order passed in 2022. How do you overcome the limitation? Where is the earlier order of withdrawal?
Lordship, in page number 58.
50?
8.
58 or 50? 58.
Lordship, page number 60 is the operative part.
60 years. With liberty to file afresh. Liberty has been granted, but it has to be done in accordance with law. What is the limitation? We are in June 2025. How do you issue notice here?
Then Lordship, in that case, kindly given answer, Lordship, as senior counsel. is
Okay, you have
recommending.
after the vacation, okay?
Okay, Lordship.
Oh.
Bless.
Heard, what is your name?
Jay Bezbura, Lordship.
Heard, you're not on record.
Lordship, actually, I am Lordship, but I don't know why counsel list is not good.
Registry does not like you.
Maybe.
Cause this is a hearing song, Wakalata Mahon song. Wakalata Mahon song. It is. You have not become a member of the bar.
Yes, Lordship, I have picked up this.
You have become.
Yes, Lordship.
Mr. Chaudhary? No, otherwise also says become a member. Another force. Maybe registry has some grievance. We have to inquire. Heard Miss J. Bezbura, learned counsel for the petitioner. Full stop. However, at the outset, the aspect of limitation has arisen. Para. On her request, the matter is adjourned to be listed immediately after the vacation.
Bless.
Item 4.
Yes, Mr. Ali?
May it please the Lord. Yeah, my lord, we have challenged, my lord, the order of award of Luka Dalat, my lord.
Loka Dalat?
Lordship.
How? Why?
My lord, the order was, my lord, obtained by playing fraud with the sisters, my lord. We are the sister, my lord.
You file a suit,
No, suit is barred, my lord. The all Supreme Court said, my lord.
then writ is also barred.
Only
If
remedy,
there's an element of fraud, there is no bar.
only remedy, my lord.
No, if you are alleging fraud,
Fraud. Paragraph, my lord,
fraud
24.
vitiates everything.
Fraud. Paragraph 24 and 36, my lord. Exactly similar case, my lord.
Twenty-four.
24, my lord.
But here you are alleging fraud. How do you establish fraud in a writ proceeding?
My lord, because, my lord, the award was passed by Luka Dalat. Exactly same case, my lord. Here also, my lord, the title suit was filed. And it was placed before the Luka Dalat. By playing fraud, my lord, award was obtained. Then the civil suit was filed. Then the learned trial court hold that, my lord, civil suit is barred. So, plain dismissed. Then preferred appeal before the High Court. High Court allowed. Then against that order, Honorable Supreme Court passed this order, my lord.
Where is the element of fraud here?
In the first heading also, my lord. In the first page, my
First page.
lord.
No, Jalur Singh case 2008 is on a different context because there is a bar to institute any case against the finding of
But
fraud.
relying that ratio, my lord, this
So
order.
Jalur Singh is on a different context. If you are alleging fraud, we issue notice, that's not a problem. But tomorrow, how do you prove, how do you establish the fraud in a writ court?
But record will show, my lord.
Records, fraud records.
Because our signatures
Fraud is something, a matter of fact.
fraud as well as misrepresentation is also there, my lord.
These are all matters of fact. How do you establish matters of fact in a writ court? Okay, we issue notice at this stage, but we do not know whether third three R Rahman, R Ali, learned counsel for the how many petitioners?
See, my lord.
The petitioners have put to challenge
It's 13. my lord. Okay.
an order dated 12/3,
Lost it.
12/3/2022,
22.
passed in a Lok Adalat, pursuant to which the respondent numbers 4, 5, 6, and 7 had filed a compromise petition for passing a decree in terms of this LS compromise. The petitioners have alleged that fraud was played upon them and the order in the Lok Adalat was passed by suppression of material facts. The learned counsel has also relied upon a case of Bhargavi so-and-so reported in 2018, 13 SCC 480 in support of his contention on the maintainability of a writ petition. Para? Let notice be issued. Returnable by 6 weeks. Ms. G. Hazarika, Standing Council Revenue, accepts notice on behalf of 1,
2 and 3.
2 and 3 as M. Burman 2 and 3, extra copies. Then 4, 5, 6, 7, registered post with AD. Steps within 2 working days. But why are you so late?
Because, my lord, we are under, we filed, my lord, petition for mutation, my lord, then we came to know about that.
Five and six.
Yes.
Look, there is an order in this matter for reflecting the name of on
NFL officer, my lord, that of course we have not carried out, 7th of April. My lord, my submission will be, my lord, the matter can be disposed of on the basis of the affidavit that has been filed by the my lord government.
As because the impugned order, if your lordship comes to page 29, the
In
vernacular.
which one? 1792 or 3784?
179.
179.
They both are connected.
In fact, no, my lord, it's not connected.
Not
The idea, there was an interim order in the, my lord, the item number 6. Because of that, my lord, this has been tagged to show that, my lord, there is already an interim protection. So far as that number is concerned.
And what about 6? 6 is a 17 matter. Who appears in 6? You are there in 6
Yes,
also.
my lord. That is
Oh.
required to be heard, my lord. Finally, because it was in the admission column, it was heard. For some instructions, it was pending.
Okay, then you say that the 25 matter can be
Disposed of.
disposed of.
Can be.
Because if your lordship kindly comes to
What
the
is it?
impugned order,
What is it about?
if your lordship kindly comes to the impugned order at page 29, 29 is the vernacular, 28 is the, my lord, translated version. This was a notice,
20?
29, my lord.
Yes.
This is a notice issued by the, my lord, co-commissioner, district commissioner to the, my lord, petitioner number 2. ইয়াৰ আপোনাক জনোৱা হ'ল যে জালুকবাৰী মৌজাৰ উত্তৰৰ জল সমজিলা আয়ুক্তৰ কাৰ্যালয়ৰ সন্মুখত ব্যৱসায় চলাই থকা নিজ জমিৰ পঞ্জীয়ন দলিল, নামজাৰি কপি, জমাবন্দী কপিৰ লগতে অন্যান্য নথি পত্ৰ লৈ অহা ইমান তাৰিখে দিনৰ 11 বজাত নিম্ন স্বাক্ষৰকাৰী কাৰ্যালয়ত উপস্থিত হ'বলৈ জানিযোগে জনোৱা হ'ল। My lord, the joint auto service is a tenant of the petitioner number 1, and therefore, my lord, both of them went there and submitted their documents regarding the ownership. Thereafter, no order has been passed, and apprehending that they'll be, my lord, evicted forcefully, they have approached this court. Now, my lord, the affidavit has been filed saying that the deputy commissioner, if your lordship kindly takes up the affidavit of the district commissioner, it says that the co-district commissioner wanted to know what is his land of his office, and the circle officer, he asked the circle officer to give a report, and from the report it appears that part of the land has been which is railway land is occupied by the people. Now, my lord, my submission is, and my lord, it has also been stated in the affidavit that they have not initiated any eviction process. So far as the co-district commissioner is concerned, it says that Joint Auto is occupying, paragraph 3, Joint Auto is occupying a part of the common land in Dock number 27, which
Correct.
is recorded in the railway.
Affidavit filed by the.
So,
Affidavit filed by the
R4.
respondent number 4,
Yes.
page 38.
Yes, yes, yes.
Lord,
then, my lord, in paragraph 5, it is stated,
Railway has not initiated any proceeding.
no, railway has not
Then
initiated.
it was
but
this.
It will,
Whenever
my lord,
if
it
there
will
is
be
any-
open for them, my lord, either
Okay.
the district
Okay,
authorities or the
okay.
railways, my lord,
Okay.
in accordance
So
with.
we segregate this and
Yes,
close
ma'am.
this. Okay. Third, Shri M.K. Chaudhary, Learned Senior Counsel, assisted by Shri M. Sharma. Also heard Shri H. Sharma, Learned Additional Senior Government Advocate, Assam. Para, considering the subject matter and as agreed to by the Learned Counsel for the parties, this writ petition is taken up for disposal at the motion stage itself. Suffice it to mention that on 7/4/2025, suffice to mention that this matter was taken up for motion on 2/4/2025 and 7/4/2025, and in the meantime, on 22/5/2025, the respondent number 4 has filed affidavit in opposition. Para, please have your seat.
Right.
As per the facts projected, the petition number 1 is the owner of a plot of land measuring 1 katha, covered by Dock number 13 under KP Patta number 109 at Revenue Village, Uttar Jalukbari, Muza Jalukbari, Revenue Circle, Guwahati. in the district of Kamrup M, which was acquired by a registered sale deed. Full stop. The petition number 2 is a tenant who is running a business in the name and style Messrs. Jain Auto Service. Full stop. On 5/3/2025, a notice was issued by the respondent number 4 to the petitioner number 2 in connection with the land in question, whereafter both the petitioners had visited the office of the respondent number 2 and produced all the relevant documents. Para? The affidavit in opposition filed by the respondent number 4 on 22/5/2025 has, however, revealed that the said exercise was done only to ascertain the area which was under the office of the said respondent number 4. First off, the affidavit also reveals that no land of the respondent number 4 was under the occupation of the petitioners, though a part thereof appears to be railway land, and further that no eviction process is contemplated to be initiated. Para? In view of the categorical stand in the affidavit, this court is of the opinion that there is no live cause of action which remains to be adjudicated in this petition. First up, the petition is accordingly closed. And then you write in the next item, item number 6. But why is it come for motion? Only because it was tagged with this.
Yes, my fact was
Oh.
with.
This matter-
is a very old case, my lord.
Has been wrongly listed. No, this matter has been listed in the motion column as there was an order to list
Okay.
along with WPC 1792 of 2025. Full stop. The said writ petition WPC 1792 of 2025 has been disposed of today. Para. List this case for hearing immediately after the summer vacation.
My lord, it was heard at the stage of admission, my lord.
Is it? List
Otherwise,
this case for admission hearing immediately after the summer vacation.
Date may kindly be given.
On
Wonderful.
list on 22nd of July.
Hello.
Item 7.
May I please, Lordship? Lordship, this matter is regarding encroachment of land of the petitioner by the respondent number 7 and 8, Lordship.
4, 7, and 8.
Private respondents, Lordship.
Private listener, why have you come to the writ court? If there is an encroachment or complaint, why have you come to the writ court?
Lordship, petitioner have filed representation before the circle officer, district officer.
You have to file a suit if they are encroaching. How will the writ court help you? Can the administration take an action against the encroachment? You have to file a suit. They are your relative.
No, related, not related.
7 and 8.
No, not related.
Where are your land documents?
There is a Miyati Patta, page number 17, Lordship.
17.
17. Petitioner's husband's name was there.
Where is the name? What is the name of your husband?
Name of
America.
Yes, the God. This is a type copy, Lordship. It is from page number 19. The original.
No sin. Translation you should have written America properly. Why have you written K? His name is America. You have written K here.
In other documents also his spelling is K.
Is it?
Yes.
And what are the documents of the respondents, private respondents? Any documents?
No lordship. There is no.
Yes, madam. Read petition. Okay, before the vacation, let us issue notice. Otherwise, maintainability will be a problem, madam. Heard Ms. D. Angana, learned counsel for the petitioners who are aggrieved by the inaction of the respondent authorities with regard to the encroachment on the plot of land, on the plot of their land by the respondent numbers 7 and 8.
7 and 8.
Full stop. Para. Whether a writ petition would be the proper recourse in such a matter will itself be an issue which would require deliberation. Para. Be that as it may, comma, let notice be issued. Returnable by 6 weeks. Ms. G. Hazarika, Revenue, Ambermont 2, 3, 4, 5, 6. Ambermont extra copies, huh? So 7 and 8 registered post with AD. Taps within 2 working days.
Yes.
Para maintainability. The issue of maintainability, however, is kept open.
Marvelous.
That's it, your lordship. Lordship, matter regarding petitioner's grandfather during his lifetime, my lord, created a work of property, my lord. Now, my lord, respondent number 4, my lord, he is neither a family member nor any relative, my lord. He is entitled his work of property, my lord, and constructed a house, my lord. Patent petitioners, my lord, he submitted his representation also, respondent number 2 and 3, my lord. Neither the dispose of his representation nor.
How will it be maintainable? Dispute between you and the respondent number 4 regarding construction, file a suit, get an injunction.
My lord, with regard to withdrawal.
You should file a suit. What is your name? Al Wazida. Heard Miss Al Wazida, learned counsel for the petitioner. Also heard Sri N. Das, learned state counsel. Para. The dispute which has been sought to be raised clearly appears to be a private dispute with the respondent number 4, wherein an allegation has been made of encroachment and construction of a building over a plot of land. Para. At this stage, the learned counsel for the petitioner submits praise that she may be allowed to withdraw this writ petition and approach the appropriate civil court. Para. Writ petition is accordingly dismissed and as on withdrawal with liberty as prayed for.
Obliged.
Item 9.
Yes, madam, what is this?
Your lordship, the matter was regarding the Chocos notice was issued on 9/6/22 under section 73 and an order dated 23/11/23 was issued under section 74 of the Act.
What is your name?
P. Sharma.
You are on record, no?
No, your lordship.
Heard Miss
P.
P. Sharma. Heard Miss P. Sharma.
P. Sharma.
Learned counsel appearing on instruction of Sri D. Saraf, learned counsel for the petitioner. Full stop. The challenge in this writ petition is against the issuance of a communication dated 29/4/2022 under section 74 of the, what is the name of the act?
GST.
Of the GST Act, Sailava. It is submitted that the said action, the said section of law is not at all applicable in the instant case. Para. Why the earlier orders, instructions were directed to be obtained, which till now has not been done. Para. Let notice be issued returnable by 6 weeks. Sri H. Barua, Learned Counsel appearing on Union of India. Union of India. Who's there in the court otherwise, Mr. Barua?
I think I'll appear for Union of India, my lord.
Ministry of Finance, no, Ministry of Finance.
GPay ko name may be reported.
Okay. Sri, is he there in the court? Mr. Gogoi, is he there in the court? Sri K. Gogoi, Learned CGC, accepts notice on behalf of respondent number 1. Whereas Sri H. Barua, Learned Counsel appearing on instruction of Sri. You're there. No. Where is Sri B. Gogoi, Learned Standing Counsel, Finance Taxation, accepts notice on behalf of the respondents 2, 3, and 4.
Yes.
Let extra copies be served upon the Learned Counsel for the respondents by tomorrow. Interim order passed earlier to continue till the next date of listing.
Oblige, your lord.
Oblige, my lord.
Item 1 pending.
Lord, I'm very sorry, my lord. Actually,
No, none was
the
there.
instructing council is also, I have no instructor also. I was engaged.
No, I
by-
think there is nothing to be adjudicated here.
Oh,
You're elected.
Yes.
Okay.
In fact, Lord may kindly observe paragraph 18 of the PI dated 33 of 2010. The direction from this division bench to comply this order, but the petitioner is delaying the process.
Huh?
In fact, Lordship may issue contempt notice to the petitioner also. They are delaying the process matter.
Honest, my lord, I was forgot about the facts also. Because the
Okay,
instructing council did not,
Okay, heard Sri K. N. Chaudhary, Learned Senior Counsel, assisted by Sri SD. You are there in the.
Mr. A. Nayak's name.
Is not there. How can I
Not
record
there,
his
no.
name? Assisted by Sri SD for the petitioners. Also heard Miss M.D. Bora, Learned Standing Counsel, Corporation Department.
Respondent number 1, 2, and 3, my lord.
Corporation Department, Para. On when the matter was last listed on 29/11/2024, a submission was recorded made on behalf of the petitioner that in the meantime, the petitioners were also elected for the society. Full stop. At the same time, Ms. Bora, the Learned Standing Counsel, has standing counsel by referring to an order dated 1/9/2016 passed by a division bench in PIL 33 of 2010 has submitted that in spite of a clear direction by the court, the petitioners are delaying the matter. Be that as it may, this court is of the opinion that in view of the subsequent development as recorded on 29/11/2024, there is no live cause of action to be adjudicated. Accordingly, the petition is dismissed.
I'm so deeply obliged.
Item 10.
Yes, what is this, Mr. Todi?
May I please, Lord? Against the refuse assessment order passed by the central GST, we are challenging the jurisdiction of the assessing authority,
Yes.
where he has exercised power under section 74 of the Central GST Act
CGST.
CGST Act, Lordship. There are multiple points of error of jurisdiction, Lordship, where first of all, he has excised.
Yes, Mr.
Lordship, they has the option of alternative remedy. They have not availed it, they have directly approved this honorable court.
Alternative remedy in the form of?
For approaching the appellate tribunal, Lordship.
Yes.
Lordship, Honorable
They
Supreme
have
Court has
challenged
already
the
held
order in
when
original date.
we have, the issue of jurisdiction is concerned, alternative remedy may not be a bar, Lordship. There are multiple issues of jurisdictional error, Lord. If I,
Also, Lordship, a ordinate bench of this honorable court has just passed the order.
Hmm.
This order is by Honorable Justice A.D. Chaudhary.
Hmm.
And on last occasion, the Honorable Justice has asked the petitioner to go through this order, and that bench has referred the matter to the appellate tribunal, Lordship. On the
Approach
ground
the
of-
appellate tribunal, jurisdictional point can be raised by you even before the appellate.
jurisdictional point cannot be taken up by the appellate authority, only the effect. But when the
Why not?
Because
Appellate
the
authority is
entire-
not going to the jurisdictional aspect.
Because the entire
That is the basis.
exercise of power, the basis of.
No,
exercise of
what is
power
this? What is
considered.
this order? No, you have seen this order?
Lordship, I have seen that is not applicable in my submission because that is pertains to the service tax under the Finance Act. The provision of law was totally different. And now in this present case,
It's not a provision of law. It's the provision of whether you have an alternative remedy which is efficacious in nature.
Lordship.
And this alternative remedy is in the form of a statutory appeal provided by the statute itself.
But Lordship, Honorable Supreme Court has repeatedly said, and in the recent case of Magad Sugar also, it is when the jurisdictional issue is concerned, although there is a alternate remedy, it may not be a bar because the Honorable Court.
No, what is your difficulty in approaching?
And
See, those contexts, Whirlpool has been said on different, it's a three principally on three grounds this Honorable Supreme Court has laid. But what is your difficulty in approaching the appellate tribunal?
At this stage where there is one part we have already admitted and we have already paid. Now he has exercised jurisdiction as 74 and he has.
Today we issue notice. After 6 months, we send the matter to the appellate authority. What purpose will it serve?
If I may submit, Lordship, in similar issue where alternate remedy was raised, but this honorable court has held that 74, under which the present assessment into not has been passed, is not applicable on the following facts, and that was set aside. Although there was an alternate remedy, this court has
No,
entertained.
he has also been, he is also equipped with another order.
Lordship, this the other order which I would rely upon in the future course is exactly similar in the same fact because there
Before we issue notice, then maintainability will be left open.
that will be left open. Lordship will argue on that also because there are issues like whether the basis
Heard
of
Dr. A. Todi, learned counsel for the petitioner who has put to challenge an order in original number so and so, Sailaba, dated 27/1/2025, issued by the Joint Commissioner CGST, confirming the demands of goods and service tax within bracket GST in a common order in original for several assessment years. Full stop. The same was done by invoking Section 74 of the GST Act of 2017. Para? Your name?
K.
K. Jain. Miss Sri K. Jain, learned counsel appearing on instruction of Sri SCKL,
Lord.
has however raised the issue of maintainability by submitting that an appellate forum is available, which is efficacious in nature. Para? He has also relied upon a recent order passed by this court whereby a matter was remanded to the appellate authority. Para? Dr. Todi has responded that jurisdictional issue, if there is a challenge on the aspect of jurisdiction, writ would be maintainable. Para? Be that as it may, let notice be issued, returnable by 6 weeks. Sri Jain, learned counsel, accepts notice on behalf of all the respondents that extra copies be served upon him by within 2 days. Para? The aspect of maintainability of this writ petition is however kept open.
Much of.
Yes, next.
Till then, no court effect.
List on 30th of July till the returnable date, no coercive action be taken against the petitioner.
But
That's the maintained resolution. Yes.
Item 12. My lord, some stalemate is going on, my lord. All that I was proposing for a lordship's kind consideration is, my lord. Yes, my lord, both petitioner and the other side appear before the bank. And let them, my lord, hash out the issue.
Other side means
The other respondent number 5, my lord.
private respondent.
Yes,
What is the issue?
actually, my lord, who is in the helm of affairs of this particular school, my lord? That is the dispute. Earlier, there was no, my lord, interim injunction was not granted. But we preferred a revision at page 33, my lord.
So how is it connected with the bank?
No, because who will operate the bank? The bank is not allowing us in spite of the High Court's order. So therefore, what I am suggesting, praying for is, my lord.
But without notice,
But
can
other,
we,
yes. that is
can we
also-
issue, can we direct
Please,
this for
sir.
number 7? Are you appealing for 7?
Your Lordship, I am for 120 Canara.
No, he is my learned friends for bank. And in that case, my lord, also will issue a notice.
We issue notice at this stage. Let them come, then we can.
Yes, yes.
Heard Sri K.
My lord, we
Chaudhary.
may be permitted dusty also.
Okay. Heard Sri K. Chaudhary, Learned Senior Counsel, assisted by Sri R.J. Das
Yes.
for the petitioners. Full stop. The grievance of the petitioners is with regard to the operation of a bank account in the respondent number 1 bank. Full stop. That there is, it appears that there is a
An
dispute.
account is in the name of the school, my lord.
It appears that there is a dispute between the present petitioners and the respondent number 7.
Yes.
7.
All the respondents, my lord.
Not-
4 to 8.
And the private and the respondent was 4 to 8. 4 to 8. And the account is in the name of the school. And therefore, the issue has arisen as to who would operate the said account.
Yes.
Para? The senior counsel has submitted that there may be a scope for amicable settlement. Full stop. Para? Let notice be issued, returnable by 6 weeks. Is it 4 weeks?
4 weeks.
4 weeks. Sri M. Sharma, Standing Counsel.
Yes, sir.
Standing Counsel Canara Bank accepts notice on behalf of respondent 1, 2, and 3. Let extra copies be served upon him by tomorrow. Let steps be taken for service of notice upon the respondent numbers 4, 5, 6, 7, and 8 by registered post with AD. Steps within 2 days. Para. Additionally, as requested, dusty service is permitted, which however is to be routed through ... That's the next date be fixed.
21st of July, my lord, 4 weeks.
21st of July. Before the next date, an affidavit is required to be in proof of dusty.
Item 13.
May please your lordship.
Yes.
Lordship, item number 13 and 31 will be taken up together, man.
My lord, this matter, the Architect Kudri is appearing, my lord.
Oh, okay.
He is in court number 2, my lord, on leg. Can be taken after some time, my lord.
Okay. 13 and 31.
Yes.
May it please your lordship. My lord, the petitioner challenged the PRC 07, my lord, on 11/9/2024, a so cause notice has been issued by the department, my lord, and for that they have also given a reply. The so cause notice is page number 53-55, and thereafter we have replied in the particular form that is DRC 06. And after that, in DRC 03, we have made the payment, my lord, by ITC. And after that also, without giving any opportunity of hearing, without giving any opportunity, they have passed the DRC 07. The page number 64, my lord, on 22/10/2024, my lord. There is a matter of 3 adjournments should be given at least, my lord. They have not given a single adjournment, according to hearing. Further, my lord, they have freezed the
But the
bank
so-called
account.
notice was of 11/9/2024, madam.
Yes, my lord, and we
And
have
the
replied.
bank account was frozen in April 2024.
Yes, it was not.
Why are you so late?
My lord, that we have given the reply on 22/9/2024. It's page number 57, my lord.
Thereafter,
Thereafter, my lord, they have passed the DRC 07 on 22/10/2024.
what is the outcome? What have they intimated?
Uh,
What has been communicated to you?
no communication was done. They have directly passed this recovery order under DRC
Yes.
07,
sir.
order 74, my lord.
Page 57, my lord. There, my lord, yes, apparently, lordship may kindly see the column 7. They opted for hearing.
Yes, my lord, we have opted
For
for hearing.
passing the impugned order. Let me have the instruction on that.
Well, issue notice then. Heard, Miss N.
Oh, I
Gogoi.
can have the instruction because my lord, the statutory provision 75(4) says that
Well, issue a short notice.
Yes.
after
Heard,
vacation.
Miss N. Gogoi, learned counsel for the petitioner. Full stop. The primary grievance of the petitioner is the action is with regard to the aspect of not giving proper opportunity before taking the impugned action. Full stop. It is submitted that the records would establish that the petitioner had sought hearing and without giving any scope of hearing, the impugned action has been taken, which includes a recovery as well as freezing of bank account. Let notice be issued. Returnable on, we give a date 23rd of July, madam. Or is it 28th of July? Sri B. Gogoi, learned standing counsel, finance taxation for all the respondents, huh? Extra copies.
I'll
Within 29 copies.
So, Lordship, this question is for a very limited prayer. Actually, what has happened, Your Lordship, the petitioner was an earlier GMC employee, and he was occupying a building which was allotted to him the erstwhile GDA. GDA was constituted prior to GMC, Your Lordship. So, sir, there was some dispute, and GMDA had claimed that the building belongs to GMDA. And against the so-called notice, we filed a repetition which was dismissed, Your Lordship, and then we filed a writ appeal that was also dismissed. So after that, but the honorable court directed the respondent, GMDA, to follow the procedure as per the Assam Public Premises Act, Your Lordship. So accordingly, again, a state officer appointed, and then a notice was issued.
Your appeal is pending or what?
So what has happened, Lordship, that appeal we have again we have been issued a eviction notice by the estate officer, against which we had issued a filed an appeal before the DC, because the appeal lies before the DC, Your Lordship, as per the Section 9 of Assam Public Premises Act. But even after more than 10 days now, no order has been passed. Neither our stay has been granted, nor it has been disallowed, nor any hearing has been conducted, Lordship. It has been lying there, and we have been.
But the matter was already adjudicated earlier.
Lordship, yes, but
again, how can you file an appeal again?
But Lordship, there are some press grounds, and also the procedure.
Appeal cannot be repeated.
That is true, Your Lordship, that cannot be denied. But as per
If
the
an appeal is dismissed, you cannot file again another appeal. It has to be either go, if there is a ladder, you have to go up, or you come to the writ court. Writ court has dismissed your petition.
Lordship, this is for a very limited direction, that if our appeal may be dismissed. But right now the appellate authority is just sitting on it, and no direction has been passed, and now the eviction date is on 29th, Your Lordship. So this is very limited prayer to give direction.
Yes,
to the,
what do you say?
My lord, I have just consulted with my current colleague, my lord, and he has said that the estate officer lies before the GMDL, not before the district.
The appeal.
GM.
Yes, Mr. Bora.
Our district, there is an order from the state officer. State officer, there is an order. There is a provision for filing an appeal for the deputy commissioner. Just file it. concern is that it has not
Then,
been
my lord,
registered. Right?
It is neither
No
been,
order has been passed.
no order.
that is their
At the
case
same
file.
time, in the appeal, they had filed an appeal, that the petition filed by, that has been dismissed, then an appeal has been filed, that also been taken care of by the court, has been dismissed. Now he has had another appeal for the.
That is exactly the question which you have put.
Yes.
In the earlier round of litigation in this court, it reveals that there was an appeal which was filed dismissed.
Yes.
Now writ petition, writ appeal, everything dismissed. Can another appeal be now under what provision?
No, Lordship, then the appeal, our appeal may be dismissed, then that is on the,
Why should we order for an order to be passed in a proceeding which does not even lie in the law, in the eyes of law?
But Lordship, the Honorable, this High Court direction only is been given to the respondent to follow the provision of law, and that the provision of law is the eviction proceeding as per the Assam Public Privacy Act, Your Lordship.
That your appeal was already dismissed earlier.
That procedure has not been dismissed, Your Lordship. What has happened is GMD had directly issued a show cause notice. They
No,
also-
the earlier writ petition, what was the subject matter?
The subject matter was.
Let us see the earlier order, 4770 of 2014.
Page number 27, Lord.
21. Twenty-six is the operative department.
26 para 2, Your Lordship.
Para 11, my lord. That's ten, 11.
In terms of that judgment, 34 has been issued to you, right? Page 34. 11.3.
Yes, Your Lord.
Thereafter,
Thereafter, we had filed a reply that, and after filing a reply, they have issued the eviction notice, and that is annexed 8, Your Lord, page number 36. But there are various procedural defects in that eviction notice, Your Lord. That is why we have challenged. One of the procedural defect is the schedule of the property given itself is
okay,
incorrect.
yes, he has the right to appeal. An appeal he claims to have filed when, Mr.
11,
Das?
11.
11 6 floors. And after that, we have issued, visited the office every day and met the DC personally, and also have filed a representation.
You take instructions.
Yes.
Okay. Third, Sri J. Das, learned counsel for the petitioner who is aggrieved by the aspect of eviction from the plot of land which is under his possession. Full stop. It is the case of the petitioner that the eviction notice eviction proceeding was earlier the subject matter of challenge in WPC 4770 of 2014 and WA 116 of 2015, and both the
1125, my lord.
116 of 2025, and both the which were answer no, I don't like equalizer. Why the subject matter was the subject matter of challenge WPC 4770 of 2014, which was dismissed, and the writ appeal number 116 of 2025 preferred by the petitioner was also dismissed. Full stop. Thereafter, the estate officer GMD has issued an eviction order dated 35/2025, against which the petitioner has preferred an appeal. Full stop. However, the appeal has not been considered. Para. The appeal has been sought to be preferred under section 9. Has been stated to be preferred under section 9 of the Assam Public Premises within bracket eviction of unauthorized occupants bracket close Act 1971. Para, let notice be issued. Returnable by 4 weeks.
My lord, otherwise it can be in this way also. Direction me pass to dispose of the appeal. Either in.
Well, I will say something. 4 weeks. 3. Yes, Mr. Das, who is respondent number 1?
Respondent number 1, my lord, principal secretary to government of Assam. No department has been there.
What is this kind of respondents? 3. You just see how have you described respondent number 1?
No, one department.
Lordship, it's a mistake, lordship.
Sri and Das Learned State Council accepts notice on behalf of respondent 1, 2, and 3. Whereas Sri S. Bora, Learned Standing Council GMD, accepts notice on behalf of respondent number 4. Para. Pendency shall not be a bar for consideration and disposal of the appeal said to have been filed. For Sri Das prays for an interim order. Para. Considering the facts and circumstances and balancing the equities, it is directed that till the returnable date or till the disposal of the appeal, whichever is earlier, the eviction order is not to be given effect to.
Highly operate.
Okay, sorry. Yes. Eviction from a government quarter. But how are you occupying?
Lordship, what has happened is earlier the GDA was there and GDA had issued.
No, understood, but you are in illegal occupation.
Lordship, what our ground is, it doesn't belong to GMDA. Lordship. That is the main ground, and that we already. GMDA didn't have the authority to issue the notice.
And who but the single bench has already held that GMC has the authority, GMD has the authority.
That we are challenging now a lot before the episode.
My lord, can it be 3 weeks, 4 weeks?
This is, you are taking the law for a ride, Mr. Das. When did you retire?
Come back. 17 years.
How can you take
Lordship
whole-
also from 1974 till 2014, your lordship, there was no disturbance. He was living peacefully, no notice was issued, and the petitioner approached the GMC and GMDA several times saying that he will ready to pay some premium and may regularize. But the person is
How
a
can it be
landless
done?
person.
How can it be done?
Government court order.
No, it is never a government. The facts are different, your lordship. So that those are what has happened is he had asked for allotment, lordship. He was given allotment. After that, he became a GMC employee and he was residing there. And
Is under consideration, page 16, my lord. For time. It says I am directed to
I don't
include
think you reserve any order from a writ court. It's a court of equity. Your conduct is highly doubtful.
75. Still
But if you are given a chance, we'll explain our stand, lordship. That is our only.
What is the stand?
Then
What is the stand? Prima facie, you are in illegal occupation of a government quarter. You are aged about 75 years. You retired from service at least 20 years back. What capacity? Wasn't it your duty to leave the quarter immediately on your superannuation? Can you hold back to a quarter?
Lordship, our stand is.
You're not your stand. You just answered the question. You don't have any obligation to hand over the quarter after your superannuation, or you stick back to the quarter.
Lordship, we are.
But,
I can, 2 days back, he even broke the law of that particular building to go by another plot of another.
That we don't have any inspection. I have not. Lordship, kindly be considered. Lordship, there are several things which are in dispute, and we have.
we are not going into those several things. We are going into prima facie satisfaction. When did you retire from service?
In
You
2009.
don't raise the issue who is the owner of the quarter now.
Lordship, there is something called doctrine of legitimate expectation also. He has been residing.
Legitimate expectation
He has been
under
residing.
what authority? Legitimate expectation comes under what this doctrine is applicable and what facts and
Because he was
circumstances.
staying there undisturbed for more
Then all
than 20
retired
years.
employees who are allotted
And
quarter
he's a
will be allowed to
landless
purchase the
person,
quarter.
your lordship, and he doesn't have any other alternate premises to pay, your lordship.
You are a government servant. There are hundreds, millions of persons who are landless. And you are describing yourself to be a landless person. You are filing cases after case in this High Court. High Court says that the GMDA will have the authority that direct that the order has attained finality. Division bench has said yes.
Lordship, please the first paragraph of the report, page number 4.
Page number
4. First paragraph. He retired on 31st May 2009.
Page 34 also, my lord, para 3, while giving the reply, GMDS categorically stated, my lord, that the Honorable High Court, in his order dated 7/1/2020 WPC, has upheld that the property belongs
we are
to
not
GMDS.
granting interim order. Sorry.
Lordship, kindly consider.
Sorry.
It is only
No,
if it is
sorry,
this-
sorry, no interim order. Issuing of notice is itself, I think, more than enough. কি করলো last ওখানে? Interim order. For the prima facie, it appears that the petitioner who was allotted the particular quarter on the virtue of his service had retired on 31/5/2009, which has been revealed in paragraph 1 of the petition itself, full stop. Being a court of equity, comma, this court is not inclined to pass any interim order at this stage. Itu mutar law, punai river itu.
Item 30.
GST cancellation, my lord. Let them apply instruction if they want. Fully covered by lordship's order, my lord.
Will issue notice at this
You
stage.
will not take fixed for instruction only.
Well,
on
notice may
motion.
go at this stage.
Huh?
Notice may go at
We'll
this
issue
stage.
notice, vacations are there immediately after the vacation.
On 14th, lordship may fix, man.
Good. I heard Sri R.S. Mishra, Learned Counsel for the petitioner who is aggrieved by the action of the respondent authorities by which the petitioner has been prevented from filing revocation application, full stop. It is the case of the petitioner that the GST returns could not be filed for a continuous period. Due to what?
My lord, because of this lack of knowledge of this GST law, my lord. Because he was deciding interior part, my lord.
Because of lack of the knowledge about such requirement. Para? The Learned Counsel has submitted that in similar matters, this court has granted, has passed orders giving relief to the petitioners. Para? Let notice be issued, returnable on 18th of July 2025 For all,
my lord.
H. Borua on behalf of
E. Gogoi.
B. Gogoi, sending counsel for all the respondents. Extra copies.
My lord. Oblige, my lord.
My lord, I had informed, Eri Chaudhary, but it's not. I can.
RK Chaudhary.
Yes.
Come, wait for a while.
Yes,
Let
ma'am.
him come. What is this matter?
My lord, this matter against the ED, my lord, what has happened in this, my lord, they have taken cognizance of a case, despite the fact that the offense that have been there, that are not under the schedule of it. And as such, my lord, we have filed a writ petition.
Offense under what? PMLA?
PMLA, my lord. My lord, and as such, we have filed a writ petition. In fact, my lord, a similar kind of a matter in front, coming out the same ECIR and same notification is already a stay by this honorable court. And these are from the same, only on his presence, if he agrees to, then it's in the order.
Yes, let him come. What do you do?
My lord,
What is your business?
my lord, we are in the liquor business.
Both the matters.
Yes, my lord, they are the employees of the, they are the employees of the person, the main company from where these ED has given up a PMLA Act.
Okay.
My lord, yes,
Huh?
my lord.
Yes, Mr. Chaudhary. Two matters, 13 and 31.
Yes.
Google it one code. Yes. Which one should we take up, Mr. Sharma?
My lord, item number 13.
13.
My lord.
13 is what? 3589.
3544, my lord.
Tanmoy Chakraborty.
Yes.
Yes. He says that there's some orders passed in earlier similar.
I would just like to point out one thing, which was not based on this here occasion. Lordship, there, the case that has been projected with the repetition is that the predicate offense since has been interfered with the court below used therein charged. Therefore, there will be no offense under the PM. Now, for a moment, I will take your lordship to the
What was the predicate offense?
some
420, 408, 120B, and 66D. So there has been discharge of all these sections except for 66D. In fact, my lord, they have filed affidavit in opposition and we have filed a reply. And the matter is,
because the submissions therein were did not cover, I would say, the submissions made by earlier, the earlier petition. Their case is that in FIR 13 of 24, the accused have been discharged, and therefore the proceedings under PMLA could not have proceeded. That's right. Now, here, Lordship will appreciate the OA which has been filed before the litigating authority. That is in pursuance of a search and seizure proceeding, the section 17 of the PM. If your Lordship will please take the PMLA Act forum.
PMLA. Section?
Section 7.
17.
One.
Yes.
where the director or any other officer not below the rank of deputy director authorized by him for the purpose of this section on the basis of information. Lordship, please note, information in his has reason to believe, the reason of such belief to be recorded in writing that any person has committed an act which constitutes money laundering or is in possession of any proceeds of crime involving money laundering or is in possession of any records relating to money laundering, is in possession of any property related to crime, then subject to the rules made in this draft, he may authorize any officer subordinate to him to enforce. Lordship, the basis on which the search and seizure is carried out is some information which the officer is in possession. Now, the submissions made by my learned friend in the previous cases were the whole search and seizure procedure was on the basis of the FIR hearing 13 of report, in which the accused have been discharged. Now, I'll take your lordship to page 69 of the instant report. 69 of the
Of three,
this convoy chapter
69.
16.
Yes.
This is part of the OA that has been filed before the adjudicating authority.
Hmm.
And lordship will please bear in mind that the OA has been filed before the adjudicating authority, not for attachment. It is for retention of the section 20. Here, if I may just read page 69, brief facts of the that an FIR hearing number 1324 dated 5/5/24 for offences relevant under relevant sections of the Assam Excise Act 1910 and sections 379, 420, 511, 53A of IPC so and so was registered by Demo. By PS Demo, Assam against Vicky Das and Ranbir Yadav, who were apprehended while transporting illegal liquor in Tata so and so carrier vehicle. Search of the aforesaid vehicle resulted into seizure of 395 cartons of Tuborg strong beer and 450 cartons of Kingfisher premium beer was concealed behind the cartons of Mimi noodles. The aforesaid Tuborg strong beer was manufactured by Nefa Breweries based in Arunachal Pradesh, and this Kingfisher premium beer was manufactured by Ether Breweries LLP based in Arunachal. During the course of police investigation, role of one Manoj Hazarika also surfaced in the police case. Police seized the mobile phone from Manoj Hazarika and a car bearing registration number so makes sense. That on 25/2024, a joint team of State Excise Department from Golaghat intercepted a truck bearing registration number NL so and so at Numaligarh, Tiniati. The truck driven by Dilip Mahato was found to be carrying a large consignment of IMFL from MTM factory. Based upon the complaint of Excise Department, FIR number 63/2024 was registered against Dilip Mahato and Arvind Kumar, the truck's owner, by Bokakhat PS Police Station for offences under Section 120B, 420 IPC. The complaint to police brought out that liquor was procured from MTM factory owned by one Ranjan Lohia.
Rajan
Lohia, madam.
Sorry, Rajan Lohia. That by later dated so and so Superintendent of Excise Golaghat reported the matter to the Guwahati Zonal Office, one of the Directorate of Enforcement, regarding seizure of consignment liquor containing soap. Now, lordship will take. There are three sources of. One is FIR 13 of 24, demo. One is FIR 63 of 24. That your lordship will find paragraph 4.4. And the other information is by way of a letter from the size. In all the cases that have been filed before this honorable court, there is a common thing. There is a common plea that the accused in FIR 13 have been discharged. Therefore, the PMLA case should not have proceeded. Now, my humble submission before your lordship is, even if the accused in FIR 13 has been discharged, there still remains two other sources of information which we have placed before the adjudicating authority. Yes, we do mention FIR 13 also, that I am reading a part of the OA. Therefore, there is no bar upon the authorities under the PMLA Act to proceed in the matter. And at this stage, what we are seeking, I'm not seeking an attachment. We are still investigating the. And the prayer.
Now, what is the proposition in Madan Lal? That if you are if you are acquitted in the predicate offense, what will be the fate of the PMLA?
PMLA will not be.
That will not go. I mean, that will not proceed. That is the. But here, yes, one has gone. But all the three cases, three sources of information are intertwined. Therefore, that we have filed the OA before the adjudicating authority. That by itself will not become another point, because still there is another case and the same people are involved.
This you are reading this 69 onwards is the OA.
This is the OA that we have filed before the adjudicate.
You want to contend that apart from 13 of 2024,
there are two
you have
cases.
mentioned 63 of 24 FIR and a letter of 13/9/2024.
That's our source of
So
information.
those may also be the source of information.
Yes.
To take action against as per section 17.
Yes. Right now, lordship, there is no action as such, because we are only asking for detention. We have not yet attached.
What is the difference between retention?
Where there is a period for it be investigating the. Then if we find that there is a prima facie case, then we will go for. When it is attached, initially it will be for 180 days, and
And
after
retention is for how many days?
that will also be for the one day.
So practically, the effect on the
Yep.
individual, the citizen, is the same, whether you use the expression attachment or retention.
Now, once we attach a property, then it will be free for us. We get the evidences, we launch a criminal prosecution, that is by filing a prosecution under section 44. That will be before the criminal court. Attachment is only for a particular period. Now we are still investigating them. Therefore, only that these documents or whatever is there. Will be there till the investigation is complete. Otherwise, this will vanish.
What kind of interim protection you are seeking, Mr.
My lord,
Sharma?
may I just submit before?
What kind of interim
Yes.
protection?
My lord, this matter is absolutely similar for the same ECIR, same named persons. We have a protection from this court.
No,
No, what is the what is
No
the
coercive action until, in fact, my lord, in the other matter.
no coercive action?
Yes. Yes, my lord.
That is, no coercive action would not mean that we cannot summon, we cannot arrest them. But they have to cooperate. They have to cooperate with the investigation.
My lord, before my lord passes the order, just under two reflections now. My lord, just on page 96, annexure 6.
Yes.
My lord, this is the ECIR. Madan Lal Chaudhary clearly states that the ECIR should contain the information that you had sought, your reliable information, before proceeding with the ECIR. my lord may see the ECIR, the source of which information and material has been received. It says FIR bearing number 0013 dated 5/5/2024, registered by Demo PS Sibsagar, Assam under section 53A1 of Assam Excise Act and section 379 Code 2034 IPC 860. Now this charges against the accused, not even named in the FIR, were dropped. It has been dropped, and the order of it is that
Okay. I heard Sri SP Sharma, Learned Counsel for the petitioner.
under the order.
No, not required.
I would just a small submission.
Yes.
The fact regarding the subsequent FIR and the letter which the
What jurisdiction are you trying to invoke?
My lord,
What jurisdiction?
my lord, read jurisdiction, my lord,
And read with?
my lord, as because my lord, section 3 of the
No,
section.
why, how do you mix this jurisdiction?
No, my lord, we
If
have,
it's a rich jurisdiction, it's a rich jurisdiction.
yes, my lord.
You have also said that read with 528 of the Bharatiya Nagarik Suraksha Sanhita.
that will come only when we launch.
That's with regard to
How can two
44.
jurisdiction be invoked in 226?
My lord,
This is registered as a writ petition.
yes, my lord, as registered as
Then
repetition.
why do you have put both the sections of law? If you are putting a constitutional provision,
My lord,
don't you think that it will enough and wide enough to cover all the aspects?
it would, ma'am.
Then you can come under revision also,
My
if
lord,
your wish. Don't mix jurisdiction like this.
my lord.
You- Hmm. Hard, huh? Who is aggrieved by the proceeding under ECIR bearing number so and so, huh? Laws by the respond number 2. Both facts are similar.
Yes,
Yes, my lord, both.
images from the same.
Okay. It is the case of the petitioner that in FIR 13 of 2024, the petitioner was not named. Not named.
Not named, my lord.
Not named. And in any case, he has been discharged.
Yes.
Separate orders, huh? He has been discharged. However, in spite of such discharge, the impugned ECIR proceeding has been initiated. Full stop. It is the case of the petitioner. Sri Sharma, the learned counsel, by referring to the proceeding, has submitted that the source has been stated to be FIR 13 of 2024 and nothing else. Para. He has also submitted that in similar cases, while notices have been issued, interim protection has been granted. Para. Sri R.K.D. Chaudhary, the learned Deputy AGI, by referring to Section 17 of the PMLA Act, has submitted that such search and seizure is to be based on certain information. And in the instant case, the information was not confined only to the FIR 13 of 2024 and 2 other sources, which finds clear mention in the OA filed before the adjudicating authority. Para. Be that as it may, let notice be issued, returnable by 6 weeks. Sri Chaudhary, the learned Deputy AGI, accepts notice on behalf of All the respondents? How is your affidavit, Mr. Sharma? What is your father's name? Do you execute an affidavit of in this manner?
Yes, my lord, the father's name has been.
Why? You have dedicated yourself to the company and you are now
No.
trying to back out. He is in the custody of Alpine Beverages.
The father's name.
He has surrendered to Alpine Beverages. Even in the cost title, we thought that maybe we checked your cost title, there is no father's name.
Yes,
Maybe in the affidavit you should have, it's not in the affidavit. And don't make your petition bulky by citing case clause. Not required.
My lord.
Not required at all. See, you have cited how many case clause? Not required. And don't file affidavit of this nature. Apply your mind on behalf of all the respondents. Para 3, Sharma, the learned counsel prays for an interim order, and in this regard has placed before this court similar orders passed. Para, considering the above, it is directed that till the returnable date, no coercive action be taken against the petitioner. Full stop. The petitioner is, however, directed to cooperate with the investigation.
My lord, let this matter be tagged along with 2430 and.
Same order, huh? Last one, returnable date 6/6. List with WPC
2430.
2430 of
2025.
Okay.
And
2430.
Matters are on 17th, my lord.
17th of July.
July.
Okay, returnable 17th July, huh? For ED. RKD Chaudhary as well as Ardhur.
Let her name be also. There are 2 cases, both of them are there.
Okay. LDB.
Much open.
Please, your lordship. In this case, your lordship, the respondent number 2 has to file the affidavit. He has not
Yes.
filed it. And with regard to respondent number 3, your lordship, service report is awaited.
2 has filed affidavit.
It has not yet filed.
You have not filed affidavit. Yes, you are for 2, Mr. Musari.
My lord.
When are you filing affidavit? While Sri R.K. Musari, Learned Counsel, has entered appearance for the respondent number 2, service report upon the respondent number 3 is not yet complete. Para, on the prayer of Sri Musari, matter is adjourned by 3 weeks to enable filing of affidavit in opposition.
But, my lord,
প্রথমত your নামটা
my
লিখে দাও।
lord, about the necessary party.
This is a contempt petition. প্রথমত
Public.
your নামটা इनका नाम लिखिए, हाँ? Sir Buragohai, where is your name?
Your lordship, my name is not clear, your lordship.
H. Buragohai.
Yes, your lordship.
H. Buragohai, Learned Counsel petition.
Obliged.
Lordship, this honorable court order has been complied with, but lordship, I have a submission, my lord. Lordship, may kindly have a look.
To impose costs.
Lordship, definitely. What is happening right now, lordship? Page 17, my lord.
Where is Mr. Mondal?
Lordship, the contempt case, lordship may kindly take up without presence of the petitioner. Page 17 of the contempt petition, my lord. Please start from page 16, paragraph
Now,
11. my
is Mr. Mondal there or not in the court? Can somebody, page 17?
Lordship, I start from page 16, paragraph 11. It's an interim order passed by this honorable court. Interim order dated, my lord, 18/12/2023. Lordship, may kindly note the date. That
In view of the above.
In view of the above, in above view of the matter, that part of the impugned order whereby The respondent number 3, that is the Registrar of Cooperative Societies, Assam, has directed to appoint a new secretary of the society temporarily in place of the petitioner and has allowed the next board of directors to take the decision on the matter of appointment of a new secretary shall remain suspended till the returnable date.
Okay.
This honorable court has suspended the order issued by the registrar. I am appearing for the registrar, respondent number 3 here. Then what happened? Lordship may kindly have a look my affidavit. I have filed affidavit in this matter.
Okay.
Lordship, paragraph 3 of my affidavit filed by respondent number 3, my lord. Lordship had got it, my lord,
Paragraph
3, my lords.
by R3,
Lordship,
19th March.
Lordship,
Paragraph 3, yes, please.
that the deponent begs to submit that in compliance of the Honorable High Court order dated 18/12/2023, passed in WPC number 7336/2023, to Lokman Hussain versus the State of Assam, the Assistant Registrar of Cooperative Society Borpeta had directed the Senior Inspector Auditor of CS Comes Executive Officer of Pasim Mandia Sampai Samti Limited, had letter dated 27/12/2023 to take necessary action immediately. A copy of the letter is annexed, Lordship. Then paragraph 4, that the deponent begs to submit that in compliance of the Honorable High Court order dated 18/12/2023 in WPC Sessions, the society held its meeting on 30/1/2024 and the resolution with agenda note number 1 to hand over the post of secretary of the society to Sri Lokman Hussain was taken. He is the petitioner, Lordship, Lokman Hussain. However, as per the communication of Sri Lokman Hussain expressing inability to perform the duties of secretary due to poor health, it was decided that the previous secretary would continue to perform the duties till Sri Lokman Hussain wishes to resign as the secretary of the society. In this regard, Sri Lokman Hussain also made a representation dated 31/24. Thereafter, by order dated 23/2/2024, Sri Lokman Hussain took over as secretary of the Pasim Mandia Sambai Samiti. When we held the meeting to hand over the charge to Sri Lokman Hussain, who is the petitioner, he refused to take the charge. And this is his representation. Is type copy is page 30 and Annex 3. Lordship, the vernacular, Lordship, I can read, my lord, page 31. প্ৰতি মাননীয় কাৰ্যবাহী বিষয়া সেশনস কাৰ্যভাৰ গ্ৰহণ সম্পৰ্কত মোক অহা 20 তাৰিখে সময় দিয়াৰ বাবে আবেদন। মহাশয়, সন্মানপূৰ্বক বিনীত নিবেদন এই যে আপুনি জনোৱা প্ৰস্তাৱ মৰ্মে আদেশ মৰ্মে 29/1/2024 ইংৰাজী তাৰিখত মোক সম্পাদকৰ দায়িত্ব কাৰ্যভাৰ গ্ৰহণ কৰিবলৈ দিছিল যদিও মোৰ শাৰীৰিক অসুস্থতাৰ বাবে মই অহা 20/2/24 তাৰিখলৈ কাৰ্যভাৰ গ্ৰহণৰ দায়িত্বভাৰ লোৱাত মোৰ অসুবিধা হ'ব। সেয়ে বৰ্তমানলৈকে সমিতি যিজনে কাৰ্যনিৰ্বাহ কৰি আছে তেখেতে উক্ত দিনকেইটাত কাম চলাই থাকিলে মোৰ কোনো আপত্তি নাই। উক্ত বিষয়টো মহোদয়ৰ জ্ঞাতাৰ্থে প্ৰেৰণ কৰিলো। This is the representation filed by the petitioner. Then Lordship, the resolution that we have taken to comply with the Honorable High Court order, it is page 24, Annex 2. Resolution number 1. Lordship, page 24, Annex 2. My lord. Resolution number 1. May I read, my lord? In today's meeting, as per Honorable Guwahati High Court order dated 29/1/2024, passed in WPC number 736/24, and as per the letter number so and so issued by the Assistant Registrar Cooperative Societies Borpeta, though former Secretary Sri Lokman Hussain was given charge to proceed with the responsibility of the society through a proposal, however, on 31/24 at around 11 a.m. due to health issue, he asked for some time to take over his office. In the light of the current situation, considering the massive workload of the society, also considering the stipulated time given by the EO for commencement AGM, Sessions will hand over in society to take the responsibility of the society in place of Sri Lokman Hussain until he gets well and resume offices. Then after that, he has resumed office, Lordship. This Honorable High Court has been complied with. But Lordship, he has, in the meantime, he has filed a representation before the authority to give him some time. And in the meantime, he has filed the contempt petition before this Honorable Court. The first order of the contempt petition, Lordship may kindly have a look. It was issued on 17/2/2024. 17/2/2024. Heard Mr. M.U. Mondal, the petitioner. Mr. Mondal has submitted that the petitioner is preferring the instant contempt petition under Section 11 of the Contempt of Court Act 1971. Related to Article 225 of the Constitution of India, alleging deliberate violation on the part of the respondent number 3 and the respondent number 6 of the direction given in the interim order dated 18/12/23 in the writ petition. The submitted date, it just says there is no necessity to issue notice to the other respondent other than the respondent number 3 and 6. Lordship. Lordship, this is the petitioner is suppressing all the facts and filed this contempt petition. In the meanwhile, Lordship, the case has been disposed of and the interim order was also vacated.
Where is Mr. Mondal?
Because with the contempt case, Malad may dispose of the matter. Because I'm
No, disposal is not the end of the matter.
Right.
What
he's
about the,
suppressing all the material factors. He
what
may
about the
dispose
conduct of the
matter.
petitioner?
Yes, the conduct of the petitioner, Lordship may kindly note. Lordship may kindly timing the matter. I can contact it.
Let's try to contact him and
Lordship may
come-
kindly direct the court master also to reflect his name, the notice board. The petition has already been disposed of and the interim order first earlier shall also vacated. But the conduct of the petitioner, Lordship may kindly have it.
Okay. After a while.
Lordship, I'm so deeply obliged.
Article 20.
Without this auto. Are we passing over 9 time being? Yes.
May it please your Lordship. Lordship, this IA has been filed looking for leave to amend or correct the post right. But my lord, on the read petition, my lord, on the last date on 28/5, notice was issued fixing the matter on 25th, 25/6. My lord, can be taken up with more lordship permits, then this IA can be disposed of.
Okay. Part 3 M. Dr. Learned Counsel for the applicant who by means of this petition has sought to strike out the names of respondent numbers 12, 13, 14 and implead a new incumbent as respondent number 12. Full stop. It is submitted that the respondent numbers 12, 13 and 14 were added as parties by inadvertence inasmuch as the said respondents had already expired.
Okay.
Now, then why do
My lord, actually, 12 to 14, my lord. Here the daughters of the daughter and wife of the
you were made parties by inadvertence as they are not necessary parties? On the other hand, comma, the new incumbent would be a necessary party. Para? In view of the aforesaid submission, comma, the instant I is allowed by striking out the names of the respondent was 12, 13 and 14 and the name of the new incumbent Sri Arun Sharma be impleaded as respondent number 12. The petitioner, the learned counsel for the petitioner is directed to file amended cost title. Yes.
My lord, in the petition, my
Read notice has already been issued.
yes, notice issued, my lord, fixing tomorrow, 25/6.
Yes. It will come tomorrow.
Yes, the list not.
No, this is already, there is already an order 25/6. It will come tomorrow. Asset returnable date, asset 25/6. Oh. Asset will come tomorrow. The writ petition may be listed as per the earlier order dated 28/5/2025.
Deeply open.
You filed it today itself.
Yes.
Highest and disposed of, huh? Vinay, highest and disposed of. Yes, next.
1032 Sahil.
Yes, Madam Begum.
Yes.
What is this?
For correction of proofread,
Potodraba, again. What correction?
Lordship, the title suit number, Lordship, it is 172 of 24. And the order of the apex court is 13/5/25.
Where is it? Page?
Page number, Lordship, 9. Second paragraph,
Yes. Title suit number should be?
170,
Why did we write 123?
Lordship,
Was any such
Yeah.
title suit there earlier in
uh,
the pleadings?
it is the CRP number actually.
Okay. Okay. Heard Miss M. Begum, learned counsel for the applicant, who by means of this application has sought correction in the order dated 26/2025 passed by this court in the connected WPC 3437 of 2025. Para. The learned counsel has pointed out that in paragraph 2 and in the second paragraph of the said order, the title suit has been written as title suit number 123 of 2024, which should be
172.
172 of 2024.
Also, Lordship, in the same,
2024.
yes, Lord. In the same paragraph, the apex court order would be Lordship 13/5/25.
She has also pointed out that the order of the Honorable Apex Court is not 3/3/2025 as recorded, but
13/5/25.
13/5/2025. Para. The records have been perused, and it appears that the aforesaid two errors crept in due to inadvertence.
Lordship, there is one more thing I would like to point out at page number 10, Lordship.
Yes.
There is the line that is there. The pendency shall not be a bar for consideration of the representations said to have been submitted by the petitioner. It ought to have been to the deputy commissioner instead of by the deputy commissioner. Page number 10, Lordship. Last.
By is okay. Consideration.
Have been submitted by the petitioner.
Consideration. First line. Pendency shall not be a bar for consideration.
Sure.
That will not be a problem. Huh? Okay. Inadvertence, para. In accordingly, it is clarified that the title suit number reflected in the second paragraph should be title suit number
170
of 2024, and the order date and the date of the order of the Honorable Apex Court should be read as 13/5/2025. Para, let a copy of this order be read as a part of the order dated 26/2025. Para, I stand disposed of. তার উপরে লিখিবা আর also heard Miss M. Bormon, learned State Council, as well as Sri E. Fukan, learned Standing Council, GAD. Order to code of 13/5/2025. Okay, order to take is the one. Date to 13/5 to clear that. Kundra vendor. Next.
Item 21 for hearing.
Make please.
But, for earlier order, we have skipped the record
Yeah, for whom?
for High Court order. Quite bulky lordship. Sometime maybe. To take it. Right.
Also, 13 matters. You cannot adjourn 13 matters. Bulky, either today or tomorrow, everyone, somebody has to deal with. You cannot escape. Yes, Mr.
Take it.
13 matter, we cannot. You can afford to, we cannot afford to. We are in 2025. Writ petition cannot wait for 12 years, 13 years. That is not the purpose of filing writ petition. Yes.
Milord, what happened, Milord, in this case, the writ petition was filed on 7/1/2013, when there was a move from the district administration to take over advanced possession of land covered by PLA case number 12 of 2006, highlighting the mandatory provisions of law like the previous acquisitions in respect of other 5 land acquisition matters. The petitioner was kept in dark regarding the acquisition trusting and the steps taken by the district administration. Accordingly, a prayer was made before this court to direct the collector office to supply the copies of the notification, declarations, awards, if any made, because at the time when the writ petition was filed, my lord, certain payments were made. So the petitioner was under the impression that as if some awards had been made. Your lordship will find from the orders of this honorable court, my lord, this honorable court by order dated.
What is your grievance, Mr. Kejriwal?
My lord, my limited prayer is that all the acquisition trusting, which is admitted by them, my lord, from the affidavits, it will be relevant.
What is the stage? Acquisition proceedings had come to an end long.
Completed, everything is done, my lord.
Yes.
Now, my lord, from the affidavit, it is clear neither the provision contained under section 4 was complied with, nor the provision contained under section 5A was complied with, nor any notice was issued under section 9, my lord. Before making assessment of the compensation, my lord, it is compulsory under section 17(1) read with section 9, my lord, to serve advance copy inviting the claims and for compensation. Nothing has been done. They have admitted, my lord, in their affidavit. So in terms of the judgment.
Now, after 12, 13 years, are you interested for a direction to declare the acquisition proceedings valid in law?
Yes,
or
my lord.
are you
My lord,
interested in the compensation part?
My prayer would be limited to for a direction in terms of the honorable apex court judgment, my lord. The acquisition proceeding can be set aside, my lord, or your lordship can direct them to pass fresh award after affording reasonable opportunity of hearing to the petitioner in the matter of assessment of compensation. And as per the provisions contained under section 2013 Act, this will be the prayer, ultimate prayer, or otherwise, my lord, in view of in the light of various Supreme Court judgment, my lord, at any stage the proceedings can be quashed and set aside, and the respondent can be directed to restore the position. I will place all those things.
No, acquisition was for what purpose?
Acquisition was for acquiring the land for drilling operation for ONGC.
That has been done, possession has been taken over by
Yes,
ONGC.
Yes.
Drilling operation started.
My lord, everything has been done.
No, the question of restoration, let us try to balance.
No, I
the-
will not pray now at this.
Let us try to balance. What do you actually?
asking-
Mr. Mazumdar, you are appealing.
My lord,
Yes.
my lord, I don't know what my learned friend has submitted, what has happened.
No,
to
he
the-
has just submitted that the statutory provisions which are mandatory in nature, there is no dispute to the proposition 4, 5,
Yes.
9A
Yes.
have been violated, and he was not given a notice before the assessment. So that is his principal claim. But the immediate question is that what is the proceeding? Proceeding has already been culminated.
Yes.
Now, we have also asked what is the purpose of the acquisition.
Well,
That was for drilling, to facilitate drilling by the ONGC. That drilling operations have also started.
Right.
So the aspect of declaring the entire proceeding bad
Right.
may not be
Possibility.
may not be a practical solution.
Right.
And so the immediate question is what alternative remedy he would be interested in.
Right.
So
Well, I'll just-
yes.
Well, I'll indicate one. What has happened here is, your lordship takes up the writ petition.
Hmm.
There was a prayer in the writ petition that there are as many as 6 LA cases.
Okay.
And in the writ petition, there was a prayer for quashing 1 out of the 6 LA cases. That is PLA case number 12 of 2006.
1 of 2006.
It is PLA case number 12 of 2006.
That was challenged specifically.
No, all these were challenged.
Oh.
And on the ground that award is not passed, these, therefore, on various grounds. Now, at least 5, 6 affidavits.
No, you have said that out of 6 LA cases,
Yes.
they have sought declared that one proceeding to be declared as ultra virus or what?
No matter all the proceedings they prayed that should be quashed.
Okay.
Now, ultimately, basically on the ground that they didn't receive the compensation,
Okay.
award was not passed.
So
But
there are 6 cases.
altogether 6 cases.
In all the 6 cases, you have challenged the LA proceedings.
Because the
Okay.
documents were not furnished, my lord.
Okay.
Now,
And-
what has happened? I'll just indicate my.
Yes.
In course of the proceeding of the writ petition, by filing affidavit one after another, I think 6 affidavits were filed possibly,
Hmm.
and it was ultimately found that award was passed. There may be some aberrations here and there, but ultimately award was passed in all these cases,
Yes.
and except one, that is PLA case number 12 of 2006.
Yes.
Here, although the land acquisition proceeding was completed, they did not hand over the possession. And there was some involvement of third party also possibly, my lord.
Hmm.
As a result, ultimately possession couldn't be taken, and the deputy collector has now informed that since possession couldn't be taken, so this can be discontinued also, or it can be dropped also.
Hmm.
So other than this, award has been, and in the affidavit reply also they have filed,
Yes.
and they have received the award also
For the 5.
for the 5.
Oh.
Now, at this stage, an IA has been filed by them, which is 2852 of 2024.
52852/24.
My lord. Yes, it's a huge petition, my lord, seeking amendment of the writ petition. So, many things are stated, my lord. In nutshell, what they want is, so far as that 12 of 2006 is concerned, that should be quashed. Other than this, in all other PLA cases, they wanted there should be enhancement of award. And my submission with your lordship, and that's why this honorable court on 2 occasions they will hear the whole matter instead of amending this. My submission with your lordship will be, if award has been passed, compensation has been received by them, and their only prayer is now for enhancement of the award, then the recourse has to be taken under section 18 because it's under the old act. Matter will have to go to the, they will have to pray for reference to the
Collector.
district judge.
Collector. Collector has to refer.
Yes, and because, my lord, for enhancement, both the parties, your lordship is aware, all the parties will have to be heard, because ultimately money will come from the ONGC, the authority for whom the, so they will have to be heard. Collector has to be heard. The person who is interested is to be heard. So this proceeding is to go back to the
No,
district judge.
let us put in a different, your words we are putting in a different perspective.
Ma'am.
You are raising a challenge on statutory grounds that the mandate of law has not been followed, which has affected your right for a fair assessment, to seek a fair assessment. You are not given notice. You did not even put the claim. Now that part ultimately can also be taken care of by a reference court. The only stumbling block will be the aspect of limitation.
Not only that.
Yes, your lordship is
Milord,
absolutely correct.
Limitation,
This will be the only issue that
Milord,
will come.
that part we can take care of because
Milord.
you are in a rich jurisdiction.
Lord, as I have stated, the writ petition was filed under the impression that some awards have already been made.
Yes.
Now your lordship will find, at least in 3 cases, the awards were filed during the pendency of the writ petition. Your lordship may kindly come to serial number. I have given a chart. Your
No,
lordship-
that is okay. No. Ultimately,
My lord, if you are passing some award during the pendency, it is incumbent to invite claims and for compensation. Without inviting you or without holding any inquiry under section 9 and 11, you cannot make any award. That is the law, my lord, laid down by the Supreme Court. And in a number of patina of judgments, even in 2024, in the case of Dinesh, my lord, Mr. Dinesh's case, this Supreme Court has set aside the award made during the pendency of the writ proceeding, since the provision contained under section 15 of the Act was not followed. That is, opportunity of hearing was not given. I will place that judgment.
no, that is okay. But
Lord,
these
are the judgments.
No, that is okay. But there is also a time limit for the completion of a land acquisition proceeding.
Yes.
From the date
Yes.
of publication of section 4 notice
My lord.
till the award, there is now, if you are insisting that the award has to be again passed, the proceedings entirely will go.
Yes.
Will it be in the interest of justice?
Milord, your lord to me. In 3 cases, the awards have been made during the pendency. Now, in terms of the Honorable Apex Court judgment, these awards have to be set aside, and they may be directed to hold fresh assessment proceeding by giving opportunity of hearing to the petition. Now, in one case, my lord, the declaration was issued in 2007, and the award is made in 2012, my lord. That is after 5 years. By virtue of section 11A, the proceeding lapsed. How they can continue, my lord?
No, that is what we are saying, that this proceeding, which starts with a section 4 notification, has to be completed within a particular time. You cannot pass an award after 20 years. If you cannot pass the award within the time stipulated, the proceeding goes.
No, my lord. Since the proceedings notification under section 4 were issued, read with section 17(4), that is by invoking urgency provision. So there is no limitation for passing an award. Under section 11(4), that is requirement to pass an award that has been dispensed with for the time being. Similarly, the requirement to issue any declaration under section 6, that is also dispensed with. Because
No, if you invoke the urgency clause under 17, will the obligation to pass an award within a stipulated time be obliterated?
yes, that can be done, my lord, because as
Let
per-
us see in Land Acquisition Act.
not obliterated, they are required to pass in view of the judgment of the Honorable Apex Court in Lakshmi Devi's case, 2015 judgment. They have to pass only, that is the stipulation made under section 11 is may I read, my lord? First, I will read section 17, subsection 1. in cases of urgency, whenever the appropriate government so direct the collector, though no such award has been made, may on the expiration of 15 days from the publication of the notice mentioned in section 9, subsection 1, take possession of any land needed for a public purpose. Such land shall thereupon vest absolutely in the government free from all income tax. Now, your lordship may kindly come to subsection 4. In the case of land to which, in the opinion of the appropriate government, the provision of subsection 1 or subsection 2 are applicable, the appropriate government may direct that the provision of section 5A shall not apply, and if it does so direct, a declaration may be made under section 6 in respect of land at any time. So the limitation prescribed under section 6 is that is not required to be followed by virtue of this section. Now, sections before invoking power.
But what about 11A?
11A. 11A is once the declaration is issued, because they are required to issue, because that is not dispensed with. Under section 17(4), that can be issued, but that is not required to issue within 2 years as provided under section 4. After the issuance of the notification under section 4, they are required to publish a declaration within 2 years. That is the requirement under section 6. Now, by virtue of section 17(4), the declaration can be issued even after expiry of 2 years. Now, if a declaration is issued under section 6, then there is a time limit for passing the award that is provided under section 11. The collector shall make an award within 2 years from the date of issuance of the declaration.
What is the, where is the aspect of time for under section 6?
First provision, my lord.
Yes.
Provided that no declaration in respect of any particular land covered by a notification under section such and such shall be made after the expiry of 1 year. Subsection 2. From the date of publication of the notification under section 4. Provided further that no such declaration shall be made unless the compensation to be awarded for service to be paid by the company or wholly or partly out of public revenue. Limitation is 1 year.
Here urgency clause was invoked.
Yes, in all these cases, without serving any notice. They have admitted in their affidavit. What they have done, they have undertaken direct compensation in respect of 12 of 06, not in respect of other. So admitted position is that no compensation was assessed, no notice was issued, as required under section 17. It is the mandatory requirement. It has been held by Honorable Apex Court in a number of judgments. I have.
Yes, how do you resolve this? You resolve this?
I'll make myself. Let's kindly take up this table I have given.
Yes.
First, we should be very clear about the facts. There are 6 cases, my lord, as I submitted. Lord, to see so far, the first one is concerned PLA case. PLA case number 10 of 2004 is concerned. Oh, thank you. Okay.
I have given also.
The last one, I'm not to kindly see. Compensation is 9,13,000 something. Award was approved on 30th of December 2013, and 100% of the compensation amount was received by the petitioner.
Okay.
Now, last we kindly see the second appeal,
Three of.
serial number 3 of 2006.
Hmm.
Rupees so is the compensation award was approved on so and 100% compensation amount was received by the petitioner.
Hmm.
Then third one, PLA case number 12/2006, award not collected. Award was passed, everything was over, but he did not collect.
Okay.
And because he, my lord, I should not say, first you kindly see the second column. Notification of so was published, it is so, and the newspaper notification so was published so. And last paragraph, my lord. ONGC abandoned the drilling plan in the land of R&T plantation Lakwa and White. Later it is so requested DC to initiate withdrawal proceeding for PLA case number so and to refund the deposited amount of 24,51,000 of additional affidavits because they could not take position. They have resisted with the help of some local people. So here there is no problem. Then serial number 4, my lord. Compensation amount is 4,79,000. Award was approved on so and 100% compensation amount was received by the petitioner. Then serial number 5, my lord. Award of rupees 24,45,000. Award was approved on 3rd of May 2012 and 100% of the compensation amount was received by the petitioner.
Hmm.
And lastly, my lord, serial number 6, 41 lakh something, award was approved on so and 100% compensation amount was received by the petitioner. My lord, only in the case of
12.
serial number 4, my lord, 8 of 2007, Lordship will find award was approved on 30th of March 2014. And Lordship is aware, the new act has come into force from 1/1/2014, 2013 act.
So even according to my learned friend,
Let
since
me-
the
sir,
award is
sir,
passed on,
let me complete. I am coming to what we are saying. Let me.
Given to force from
1/1/2014.
1/14.
Right.
Yes.
And in terms of section 24 of the new act,
Yes.
if the award is passed after the new act came into force, then it is be calculated in terms of the new act.
13 Act.
That may be his prayer. I don't know whether he's making or not, but under the law, possibly that could be his prayer. In view of this, my lord, so far as enhancement of amount of compensation is concerned, here he may have a case, and for this, since it is a question of enhancement of award, he has to take recourse to section 18. Other than this, my lord, he has taken 100% of the amount. Now, by making this,
And under this, in this PLA 8 of 2007, it
2007, yes.
it might be 64. Is it 64? What was it? New Act?
New
section 64,
64, I think.
yes,
Yeah.
yes.
that has to be referred to authority.
And my
But I have heard, my lord, some new amendments also came.
my lord, your lordship is aware that this section 24 came up for consideration before a judgment passed by on court recently, my lord, that Delhi Development Authority versus Manohar Lal. There, section 24 was interpreted. Now, that being the position, my lord, lordship will kindly see he may have a prayer for enhancement. Now, he's indirectly, although he's asking for amendment of the IA, but if your lordship goes to the prayer in the IA, I'm just referring to what my learned friend is now trying to project. Lordship will take up the IA because this is
2852.
Yes.
my lord, lordship will kindly turn to page 51.
5-1.
5-1. This is how the prayer in the writ petition is now thought to be amended.
Yes.
Now, the first prayer at page 51 is that award dated PLA case number. Now, PLA cases are mentioned. PLA case 3 of 2006, 3/5/12 of 2000, PLA case number 1 of 2008, then 6 of 2010, 10 of 2008, 1, 2, 3, 4, 5 he has mentioned here. And the prayer is that being illegal and incomplete defiance of the mandatory provisions of section 4, 5A, 6, 9, 11, 12, and 17 of the Land Acquisition Act 1894, as well as section 21, 23, and 24 of the Right to Fair Compensation and Transparency in Land Acquisition Rehabilitation Act 2013. First prayer. Second is in court, my lord. Award dated 13/3/2014, passed in PLA case number so. This is the case I was referring to, 8 of 2007, in respect of land owned by the petitioners Lakwa T Estate, having been passed in violation of section 24(1)A of the 2013 Act by applying the provisions of. So here, what I said, my lord, this is what it says. Second, next, my lord, Roman 3. As to why proceedings are taken in PLA case number 12 of 2006, concerning the land owned by Puna T Estate to 20 question, set aside. 12 of 2006, I have submitted, my lord. The point itself is saying that we do not want because we could not take the post. Next is, my lord, as to why the response number 2 and 3 shall not be directed forthwith to restore possession of the various strips of land covered by PLA case number 3 of 2006, 8 of 2007, 1 of 2008, 6 of 2010, 10 of 2005, all these 5. Or, in the alternative, to pass fresh awards in respect of the PLA case numbers.
That Mr. Kejriwal has said.
That's what I'm saying. There is no concept of passing a fresh award. If you are aggrieved by the action taken by the collector that the compensation has not been determined in terms of the new act, if you can establish that compensation has to be determined under the new act, then it is by way of preference. But enhancement is only by way of preference under section 18, under the old act. Because all these proceedings were initiated under section 18. So proceedings will have to be now completed under reference under section 18. My lord, I have handed over one judgment you will find. In a recent case, a similar issue came up.
Report, a high court case.
My lord, this is no report, my lord.
No, Kesari.
Yes, my lord. Similar issue arose here also. But here the acquisition was under the Assam Land Acquisition Act 1994. And paragraph 7, Lord Kind. Be that as it may, the fact remains that an award.
Can you give a copy to Mr. Kejriwal?
My lord, yes.
Mr. Kejriwal, kindly note a judgment.
He may know the client also by. I'll hand over a copy. Para 7, my lord. Be that as it may, the fact remains that an award had already been passed in terms with section 12 of the Act of 1964. Any person who is aggrieved as regards the inadequacy of compensation can seek a reference to collector for the purpose of referring the matter to the court for determining the compensation as entitled under the law. This court also is of the opinion that once award is passed, the state award becomes conclusive evidence between the collector as well as the person interested, and the same cannot be tinkered with unless and until the same is done in accordance with the provisions of the Act of 1964. Under such circumstances, it is the further opinion of the Honorable Court that this court, under Article 226 of the Constitution of India, ought to exercise its extraordinary jurisdiction in the present facts, but for the ends of justice, ought to grant liberty to the petitioner to approach the collector, that is the District Commissioner, Kamrup or Amingaon, by submitting an application seeking a reference to the court.
Under the circumstances, it is further opinion that this court ought not.
Yes.
You have left out not.
Yes, my lord. Yes, ought not. Yes.
Ought not.
Ought not to exercise its extraordinary jurisdiction in the present text.
But in the interest of justice,
yes,
have given the liberty to approach the collector.
Yes, my lord. This is what I am saying, my lord. Because that was under that act of 1964. Here also, my lord, if the ultimate prayer of my learned friend is that in the alternative, you calculate the compensation in terms of new act, that he has to establish. This Honorable Court will not enter into all these things. Because ultimately the power to enhance is under section 18 by way of reference. So all that, as the Lordship has indicated, the question of limitation may come. That possibly subject to court consideration. He has to approach the collector.
Think of a practical solution, Mr.
Lord, I will place two judgments, one division bench and one single bench judgment. I have given a booklet, compilation. Your Lord may kindly come to page 17.
No, judgment is okay, even without this judgment.
No, that deals with this proposition.
What would be your practical, how do you address?
it deals with this proposition, awards were set aside since the award has been made violating. And the collector is directed to pass fresh award, and whatever the amount has been paid, that will be treated as interim payment, and that will be adjusted from the new award that will. For that proposition.
Yes, yes,
Because
Mr.
award has to be passed by him.
Mazumdar.
Under what circumstances that order was passed by you?
I will place below. Page 78.
Of the compilation.
Yes, sir.
Because New York says if the award has not been passed, in all cases except one, award was passed before the New York came in.
First, your lordship may kindly take up page 76, and the relevant order is your lordship will find at page 77. It is incumbent upon them to comply with the requirement under section 9 and 11.
Okay,
That is
Mr. Mazumdar, kindly look paragraph 20 of this at page 81.
Page 81. Lakshmi Devi.
No, RN plantation only.
RN
Just
Kipla.
before that, just before that. Just before that, Justice, Honorable Justice A.K. Goswami.
A.K. Goswami.
Yes, yes. Para 8, my lord.
Para 20.
This is what I'm saying, man. Awards were not passed, admittedly, prior to the coming into force of the Act of 2013.
No, that thereafter.
There being the position, the restrictions are allowed directing the collector to pass award in accordance with law as per the provisions relating to the determination of compensation in terms of Act of 2013. Such exercise shall be completed within a period of 4 months from today.
What Mr. Kejriwal is submitting, what we have understood, that the passing of the award is in a flawed manner. So he wants the reassessment, the reconsideration of the material facts by the authority, namely the collector, and pass an award. And once the award is passed, if he is aggrieved,
Then I
he
will
can
approach
put to
the-
the reference that in that manner the question of limitation would also perhaps not come in. And so far as the PLA 12 is concerned, that has already spent its force. The land is so PLA 12 will be outside the purview of this kind of an order, which we are just trying to explore, if it is possible. We'll come back at 2 o'clock. But if we have this kind of a precedent, that the award can also be passed. But
here, only one difference will always remain. Paragraph 21st sentence says, admitted position that the awards cannot pass. In our case, except one.
yes,
In all of the
no,
cases,
that
award was
will
passed.
that will say.
Because once award is
No, that will clarify that the application of 2013 would be only in one case.
Well,
Out of the 6 cases, one has already gone out of the purview, spent its force. Remaining 5, one will come under the 13 Act, rest under the 1894 Act. But the award has to be passed anew, and if he is aggrieved by the adequacy, he has the without going too much into details. That is what we think would be. But only the proposition which we have just trying to explore, whether it will be correct to direct reconsideration and passing of the award after so many years. That is one thing.
that is one.
Kindly see this judgment by Honorable Justice Goswami. Under what context?
I'll tell you.
We'll come back at 2 o'clock.
Even this matter was taken up before the division bench.
Yes.
Division bench has directed to treat the payment as interim.
No, that mechanism,
And to adjust.
that mechanism we can follow, but whether we can give a direction to pass an award after more than a decade. Of course, the writ petition is pending.
Milord, writ petition is pending. In fact, the writ petition itself was filed in 2013, when the awards started passing the award, and the petitioner was under the impression the award has been made. And in 3 cases, award has been passed during the pendency. So how can I approach before any authority, my
Okay,
lord?
okay, we'll come back. Yes, Mr. Mondal?
It has become infructuous because the order has been right.
No. But you had made a wrong, why did you institute this contempt? There was an undertaking by your client that you were in poor health, give it to somebody else, then I'll take it over. In
Yes,
spite of it, you have filed a contempt. Why did you file a contempt?
that was the blood instruction blood given by the blood other side blood. So for my contention is concerned blood after the.
No, on record, there is a letter given by your client
My lord.
saying that due to poor health, you may not be handed over charge. But later on, and a resolution was also taken. And subsequently, charge was handed over to you. But in the meantime, you had initiated contempt proceeding. Why?
Yes, it was, my lord, this letter, my lord, given by the petitioner, it was taken under threat, my lord.
Where have you stated?
Yes, that was.
Where have you stated? If it was taken as threat, then for entire time it would have been taken.
My lord,
Why?
in that case, let it be posted any other day, my lord.
You file an affidavit.
My lord.
You file an affidavit. The contempt petition we don't entertain in this manner. You might have to face some other things. Heard M.U. Mondal, learned counsel for the petitioner, who has submitted that the petition has become infructuous. Para. On the other hand, Ms. M.D. Bora, learned counsel appearing for the respondent number
3, my lord.
3, has submitted that the present proceeding was instituted by grossly abusing the process of the court, full stop, by drawing the attention of this court to the affidavit in opposition filed by the respondent number 3 on
96.
19/3/2024. She has submitted that the petitioner had himself issued a communication
Dated 31/2024.
dated
1.
30/1/2024, whereby he had informed about his ill health and to give the assignment of the post of secretary to someone else till he becomes fit, full stop. Thereafter, a resolution was taken by the concerned Samabhai Samiti, full stop. Subsequently, on 23/20/2024, when the petitioner had reported with his fitness, he was allowed to function as secretary, full stop. The said affidavit, Sri Mondal Learned Counsel has submitted that the letter was written by his client as a letter was extracted from his client under threat, full stop. However, till now, no affidavit has been filed in that regard. Para. The proceedings in the court are sacrosanct in nature, wherein it is the paramount duty of all the litigants to approach in clean hands, with clean hands. Para. It is also the duty of this court to be vigilant on the said aspect. Para. In the interest of justice, 3 weeks' time is granted to the petitioner to file an affidavit. Full stop. Consequent orders will be passed on the next date. List this case on 23rd of 28 July.
Lord, Lords may kindly observe this petition is already disposed of. Its interim order has been vacated.
She has also informed that the connected writ petition WPC so and so has been
7/26.
disposed of and the interim order has been vacated.
Deeply obliged.
Okay, at 2 o'clock.
Let me place some text thereafter you load time. You'll also may kindly take up the chart below.
Which one?
Concerning 5 acquisition, this was the chart.
Yes.
So the column 2 deals with the provisions of law, and column 3, 4, 5, 6, 7 deals with the various land acquisition act various land acquisition proceedings. Now the requirement area, etc. What is the requirement where what has been complied with or not, that has been given. Now, my lord, as far as the area involved is concerned, that is shown at serial number 2, my lord, in each of the cases. Now, gazette notification, your lords will find in the respective cases that has been published. There is no dispute regarding publication of the gazette notification. Now, publication of section 4 notification in 2 newspapers. This is the mandatory requirement that the notification has to be published in 2 newspapers. Your lords will find at page 116 of the AO filed by my learned friend, only 1 paper publication, and in respect of other 4 cases, there is no paper publication. So this is violative of requirement under section 4. Now your lords will circulation of substance. There is no circulation, there is no evidence to show that the notification issued under section 4 was served upon the petitioner or to the locality. Your lordship may kindly take up their affidavit. What is the stand, my lord? That your lordship will find at page, running page.
Affidavit in the writ petition?
In opposition, my lord. Page 59, running page 59. Paragraph 9.
Yes.
As regard para 9 of the writ petition, the deponent begs to submit that the notification issued under section 4 of the LA Act and declaration under section 6 of the Act are published in the official gazette for information to the interested person, general public. The owner of the land cannot claim the service of the same by collector. Further, as the original notification declaration are with the revenue department, the owner can approach the appropriate authority. The matter has been informed to Sri Diganta Bora, learned advocate, who applied for the document. Now, my lord, there I have given 3 judgments of the Honorable Apex Court. The notification issued under section 4 is required to be served personally upon the person affected, likely to be affected by the acquisition. That has not been, they have admitted. Even the advocate who applied, he was relegated to the appropriate authority. So there is no compliance with the requirement of section 4 and 6. That is the admitted position, my lord, from this affidavit. Now your lordship may kindly come to requirement of section 6, my lord. Serial number 6. Compliance with the requirement of section 5A, notice inviting objections. Your lordship will find from running page 87, their affidavit in additional affidavit. I will take your lordship to page 87, relevant page 87 below. No, page 89 below.
Yes. Yes.
This is additional affidavit dated 3/12/2013 below.
Yes, which one?
Last page, further, my lord, have your lordship got it?
Yes.
Further, it is humbly submitted that as per Gazette notification dated such and such, it was specifically mentioned that in exercise of the powers conferred by section such and such, government have decided that in view of the urgency of project, provision of section 5A of the Act shall not apply to waste or arable land, hence provision of section 5A are not applicable in the. That means there is no compliance. Lord, I have furnished two judgments of the Honorable Apex Court because the Acquisition Act is a expropriatory legislation where the government is exercising the power of eminent domain. So only protection provided to the landowner is to file its objection if he is aggrieved by the any acquisition. That even if 17.4 is invoked, it has been held that provision has to 5A is to be applied. That is admitted position, they have not complied. Now you also may kindly turn to next page. Regarding section 9 of the Land Acquisition Act, the preliminary LA formality like joint spot verification on land measurement and demarcation including assessment of GRAT of the same land were jointly completed with the representative of the Tea Garden Authority, which covers the LA formalities under section such and such. During spot verification measurement and also at the time of enumeration of Dhirat and R&T Plantation Limited, Lakwa did not raise any objection and duly signed in the assessment list towards payment of compensation. Now these requirement of section 8 and 9, the stand taken by them is that they have carried out the joint enumeration, that is the properties which are likely to be damaged by virtue of the acquisition of the land, that has been carried out. So there is no requirement to issue any section 9 notice inviting claims in for compensation. So section 9 also remains uncomplied, which is the requirement for invoking under power under section 17.4 unless the conditions contained under section 17.1 and 2 are complied, the land cannot vest. That is the judgment of the Honorable Apex Court. I have given supplied me. The copy of the said judgment is also supplied. Now, my lord, in terms of a number of orders passed by this Honorable Court to bring on record the awards and the compliance with regard to section 5 and 9, they filed as many as 4 additional affidavits, and those were controverted, and I have taken necessary pleadings that in view of the non-compliance of the provisions, all land acquisition proceeding vitiates, and the land is required to be restored to the petition. It is only when this Honorable Court passed an order directing the DC to appear before this Honorable Court, they filed an additional affidavit on 6 to 17. Only in 2017, they brought on record the copies of the award. That is filed on 6 to 17. This is flag I, my lord.
Flag I of?
I of the record, my lord, that starts from running pages 219 mil.
Yes. Yes.
So for the first time, my lord, the copies of the awards were filed before this Honorable Court in 2017. Now your lordship is aware, as has been held by Honorable Apex Court, that along with the notice issued under section 12, the copies of the award is to be served upon the affected pattader so that he can exercise the right conferred under section 18. He can effectively exercise the right conferred under section 18. Without furnishing, how can I exercise? And these were furnished during the pendency of this writ petition, my lord. Now, your lordship, I will take your lordship to certain judgments, my lord. Before that, your lordship may kindly take up section 11, my lord.
Yes, section.
Before that, your lordship, section 11 of the Land Acquisition Act 1894. my lord.
Yes.
On the day so fixed or any other day to which the inquiry has been adjourned, the collector shall proceed to inquire into the objection, if any, which any person interested has stated pursuant to a notice given under section 9 to the measurement made under section itna, such and such, and into the value of the land at the date of publication of notification such and such, and into the respective interest of the person claiming the competence shall or make an award under the agent of such and such. Now, my lord, the requirement under section 11 is, first he has to issue a notice, I will file an objection, I will also submit my claim. Thereafter, an inquiry is to be held and an opportunity of hearing is to be furnished to the affected party. Thereafter only he can proceed to pass an award. Without following this mandatory requirement, he cannot pass any award. In this case, my lord, in all the land acquisition cases, these proceedings have been violated. So the award made is nullity. Now, your lordship may kindly take up the compilation.
Judgments.
Compilation.
Judgments.
Yes, my lord.
Yes.
First judgment starts at page 8, my lord. Before that, my written submissions are there. My. Relevant would be page 18, my lord. Para 29. The para 13 is quoted, my lord.
JNK case.
My lord.
JNK case. Housing Board.
JK Housing Board. Relevant para is 29.
29.
29. Wherein a earlier judgment, paragraph 13 of earlier judgment was quoted. Tenth line of subparagraph 13 below.
13. Yes.
10th line of subparagraph 13 below. That provision of the section requiring public notice are mandatory, and the legislature thought that it was absolutely necessary that the owner of the land should have a clear notice of the proposed activity. Now, your lordship may kindly come to page 25 below. Another judgment.
Where did you read just now?
This is 10th line of subparagraph 13 of paragraph 29 below.
10th line, 1, 2,
10th
3,
line.
4, 5, 6, 7, 8, 9, 10.
Section 4 requirements were quoted previous.
State of Rajasthan in Khubchand.
Yes, ma'am. That was Syed Hassan Rasul Numa and Khubchand.
Yes.
So notice has to be served. Now this similar view was expressed in two other judgments that your lords will find at paragraph 14, page
No,
25.
there is no proper, these are all tried to.
Now your lordship,
they're not
now
these
my
are all
lord,
settled.
now as far as
You give us the solution. How do you practically deal with the solution?
the solution would be, my lord, since all the awards have been made in violation of section 5A, and there is a recent judgment of 2024 by the Supreme Court. The award came to be passed during the pendency of the writ petition. The Honorable High Court in that case has held that the writ petition is infructuous because award has been made in the meantime. Supreme Court has held that since the mandatory sacrosanct requirement to follow section 5A is a sacrosanct provision, since that was not followed, the award is set aside. That is 2024, your lords will find.
No, that we said thereafter what will happen?
So, my humble submission is the proceeding can now be started from the stage of calling for the claims and object. Thereafter, they will pass fresh award. Unless an opportunity, I will make submissions or the rates, etc., my lord. What should be the rate of my land? I will submit. Thereafter, they will pass the award. After
No,
hearing both the parties.
No, Mr. Kejriwal, that is okay. That is strictly in accordance with law. But to reduce the length of, see, this matter is pending since 2013. Instead of, in principle, we agree with you. But instead of remitting to the stage of calling for objections, what about the aspect of initiating a reference by an application made by you to the collector? Collector can refer the matter under 18. You have the same opportunity.
My lord, there are judgments of the Honorable Apex Court. When the statute prescribes a limitation, even the court cannot extend the limitation. Even the court does not have the power to extend. I can place those judgments, my lord.
No, your matter
Here
was
there is
your matter was in this court was in session of the matter.
So the award has been made in 2012-13, and there is a limitation of 6 weeks, my lord. So that cannot be extended, my lord. So the only course open for this honorable court, as has been held in a catena of decisions, the award has to go. If the award is set aside, because that is a nullity, my lord.
Let us see 18 again. Let us see 18 again.
Section 18. Reference to court.
To subsection 2.
In subsection B, within 6 weeks from getting a notice under section 12. Now, the requirement under section 12 is to furnish a copy of the award that has been supplied only in 2017 pursuant to various orders passed by this honorable court. And the award have been made in 2012, 13, 14.
Mr. Mazumdar, how do you overcome the limitation?
Which decision, madam?
Limitation.
Hello, limitation, lordship is exercising power under Article 226. As your lordship last, in that case also the Honorable Court is passed an order. Now, if your lordship goes to section 18, subsection 1, it has the power to do everything, lordship, you can say, whether his objection to be made to the measurement.
No, we are not on the exercise of powers by the reference court. We are not on the exercise of powers by the reference court.
No, my lord. Power to refer it to the,
Reference would be made by the collector.
yes, he
Now,
will make the application.
now the application first to make the reference by the collector, an application is required to be made in terms of the second subsection.
My lord.
Now there is a limitation prescribed, which
Yes.
Mr. Kejriwal has rightly pointed out.
My lord.
There are two conditions, whether if you are present, if you are not present.
Not present.
Now, here in this case, let us give the maximum benefit to the petitioner
Right.
so far as knowledge is concerned.
Right.
He was not aware that the
Award.
award has been passed. And in the meantime, the prescribed period of limitation has expired.
Right.
Even under subsection B, the maximum period is 6 months, whichever will expire first.
Yes.
So there is no dispute to the
Right.
fact that it has become time barred strictly if you go by
Section 80.
to 18 to B is 2 is concerned.
Right.
18 2 is concerned.
Right.
Now, will it be on the will this court have the power to
Because, my lord, so far as my submissions, but so far as the petition is concerned with the exact amount of
no
compensation.
that part we are with you.
Ah.
That ultimately a fair assessment is
Either-
the
either-
fair assessment is the
Yes,
is
yes.
the claim it will be the cause of justice also. Whether it will be accepted or not, it's a different matter, but
Right.
it has to be considered.
Yes.
He has all the rights to make a claim which he thinks would be a fair assessment.
My lord.
Now, it will be upon the consideration of the reference court, he has to deduce evidence, all those
Yes.
things, contemporaneous materials at that time of acquiring. But while doing so, there is a restriction in the form of limitation.
And
Now-
even other, if we go by the provisions of the Act also says that if once the award is passed, it is final. If we go by that, then it's final, it cannot be touched. Your lord is exercising power under 226. Your lord may always say that no, since the matter was pending before this honorable court, number one, and number two, award was passed subsequently of which he didn't have knowledge, he will be given the liberty to approach the collector.
If the learned AG is making this submission, we can record his submission.
Because
Milord,
before
you want to have a fair chance
yes,
to make a claim which as per you will be a reasonable and fair claim.
and reference court has the full power to deal with every aspect of the matter.
Your lordship may kindly consider 2-3 things. First, my lord, the proceeding initiated against thee is violative of section 4, 5A, 6.
No,
Fine.
Mr. Kejriwal, don't go back. We have those are established principle.
If established, then the award is a nullity. So as on date, there is no award. What will be the course in terms of section 24? They have to pass a press award in terms of 2013 Act. That will be, yes, the rate will be as on the date of the rate of the land, my lord. That will be as on the date of the issuance of the
That
notification.
part we may not be able to endorse. We cannot, if for one case 2013, yes. But rightly or wrongly, the award in the other cases.
My lord, in 2013, just before the new act came, keeping the petitioner in dark, these awards have been made, my lord.
That
In 2013, last December or November.
if it's a date is there, it's there. We cannot just. But for the other cases, yeah, one case, yes, you have it can be considered. For which one?
Only one case I have mentioned. That is
8 of 2007. PLA case number 8 of 2000.
8 of 2007. That was after the New York came in.
Yes, 8 of 2007. That can be treated differently.
Yeah.
Now, my
And-
lord, as far as 3 of 2006 is concerned, my lord, the declaration is issued in 2007 and the award came to be passed on 2012. So that is a nullity by virtue of section 11A. The award has to be made within 2 years. It is the requirement under the mandatory requirement. And this has been held in 2015 Lakshmi Devi's case by Honorable Apex Court. And my lord, as far as land acquisition provision is concerned, it has been held in Vidya Devi. I have given my lord the judgment at paragraph 10(7) and paragraph 11. So this is a continuing cause of it. There is no limitation as far as the petitioner approaching. And there is another judgment that the land acquisition proceeding can be assailed at any stage, my lord. That judgment I have also given. Since I have assailed, my lord, at the time when I was under the dark, when they were supposed to take over possession of my land covered by PLA case number 1206, violating of all the mandatory requirements.
Let us see what are your pleadings.
My lord,
Let us see what are your pleadings.
first, your lordship may kindly take paragraph 9 of the writ petition. This is in respect of 5 PLA cases, my lord. This pleading is.
Let us see, just a minute. When was this writ petition filed? Which date?
7/1/2013. my lord, pleadings your lords will find in the additional affidavit below, because the documents were brought by virtue of the various courts order, my lords. And accordingly, I also file my additional affidavit taking additional ground. That your lords may kindly come to,
Let us see the relief which you are praying.
my lord.
Let us see the relief at page 29 of the writ petition.
As far as first part is concerned, that is regarding 12 of 2006, my lord.
Correct.
That is gone below. To forthwith supply the copies of declaration, notifying award and other proceeding inquiries held by him in connection with these things, so that the petitioner can make a reference. Now, my lord, at the beginning itself, I have stated that the time when the writ petition was moved, the petitioner was given an impression that awards in respect of all the acquisition proceeding have been passed. And because some payments have also been made, that you will find I have mentioned in paragraph 10 of the writ petition. But it is only after the direction issued by this honorable court on 10/4/2013. This honorable court directed them to bring on record copies of the award. That was since the award is yet to be passed in respect of 3 cases. So those were never placed before this honorable court. Thereafter, this honorable court passed an order, my lord, on 31/5/2013, my lord.
Yes.
Directing them to bring on record the compliance with regard to section 5A and 9. And thereafter, on 16/8/2013, the learned advocate appearing for respondent, Revenue Department, he prayed for time to bring on record the compliance with regard to section 4(1), section 5A and 9, to bring on record the documents. These documents were thereafter filed, and thereafter several orders were issued because the awards were not filed. Accordingly, Honorable Justice A.K. Goswami directed personal appearance in 2016, and it was only in 2017, 6/2017, these awards were brought on record. That is after passing in respect of 3 cases, these awards have been passed in 2013 and 14. Last part of in November and December in 2 cases, and in 1 case in March 2004. So I have incorporated my pleadings in the additional affidavit. As I got the copies of the documents, I have incorporated violation. What is the violation? Your lords will find in my first affidavit, my lord. That is, your lords may kindly take my additional affidavit dated 26/5/14. The running page will be 192.
Yes.
Page 193, subpara, the deponent states that the deponent states that recently on 29/4/14, after filing of the aforesaid additional affidavit, the deponent received a notice that it issued under section such and such from the office of the Deputy Commissioner Shivsagar, informing the deponent that an award has been passed by him on 5/2/14 in connection with the land involved in the state PLA case number such and such, but copy of the award has not been supplied to it. The deponent states that admittedly on the date of passing of the aforesaid award, the right to fair compensation and transparency in land acquisition and resettlement and rehabilitation act came into force with effect from such and such. As such, as per provision contained under section 24(1)(a) of the Act, the respondent number 2 ought to have applied all the provisions of the state act for the purpose of determination of compensation, but the respondent number 2 having not determined the compensation as per the 2013 Act, the said award is not sustainable in law and is nullity. The possession of the land covered by aforesaid PLA case having also been taken taken away without complying with the requirement of law, the authority may be directed to restore the possession entity of the land in favor of the deponent and to pay compensation for the damages caused to land and standing terms as well as pay rental compensation for the same. Alternatively, the respondent may be directed to redetermine the compensation payable to the deponent by taking into consideration the provisions of 2013 Act. Now, your lordship may kindly take my affidavit, additional affidavit 21-115, page number 198.
But the award date is 13/3/2014 in PLA 8.
Yes, 2014.
No, 13/3/2014, and the 13 Act came into force from 1/1/2014. Mr.
The
Mazumdar
award was passed in 2014. Will.
yes, after this date, after
Yes,
coming
yes.
in. So he has very fairly said that so far as 8 is concerned, 8 of
Yes.
2007, it may be governed by the 2013 Act under Section 24.
24.
There is no
Now,
problem.
if there is violation, I will place further judgment. I have given the compilation. Your lordship may kindly come to my additional affidavit. It starts at page 190.
No, to cut things short, you ultimately want that the award should be passed afresh by giving you an opportunity to place your case. And since the awards were passed in the pendency of this writ petition, this court can direct that since there was violation and at least notices were not, you are not given a fair opportunity to place your case, it can be passed afresh. I think that, what do you say about that? Because this will be an unending matter. See, violation, if you go to the aspect of violation, he may make out a case, but will it be a practical solution? After drilling operation started, a long time has passed, more than a decade.
My submission is also kind. My learned friend's client is interested in a fair compensation.
Yes, yes.
Now, there is no difference with regard to the power of the collector and the reference court to award compensation whichever is fair. Why my learned friend wants to go to the collector? Why not to the reference court? Because my learned Section 12, Lord may kindly have a look at Section 12 of the Act. It says the award, once the award is passed, it becomes final. And there is a judgment of our High Court panel where it says, relying on Supreme Court judgment, that once it becomes final, there is no question of review of the award. Only clerical error.
No, the state judgment perhaps will not be applicable with the, because award to become final, to attain the aspect of finality, has to go by the rigors of law.
Yes.
It appears that there was no strict compliance.
Assuming that there
Even
was
if we go for substantial compliance, that may not be enough, because compulsory acquisition, that is the only remedy. We cannot stop compulsory acquisition.
My lord, in fact, in that judgment, it has been further clarified
Yes.
that it is final so far as the parties are concerned.
Yes.
But as regards the determination of amount of compensation, it is not final. Reference court will do it.
No, final in the context of whether you have abided by the statute. In the J&K case where it was, I think, which you remember, even there are many other cases that these are matters of compulsory acquisition. You don't have much of a say.
Right.
So far as the acquisition is concerned, the only say is
Because
whether
not public.
the public purpose or company, those are bona fide aspects should be there.
Yeah.
The acquisition part, you don't have much of a say, it's restricted. Your say is only on the aspect of a fair compensation,
Compensation.
for which 4, 6, 9A, 5A, all are mandatory. Or there is no other way.
But
And
sir,
4 mandatory means not only paper publication, it has to be in 2 paper, one has to be in vernacular.
language.
There has been cases where it is published in English language in a vernacular paper, whether it is, court says no.
Two
Vernacular
papers.
means the notice also has to be in vernacular. To
Yes.
that has extent the court
Yes.
has. So these are
This is in JK Housing Below.
Publication is mandatory. I am only
in
placing.
one of the first cases that, what was the name? Naren, I think, Narendra. I forgot. This is matter of the state can acquire, provided it is for a public purpose or for a company. There is no doubt.
Even under Section 5A, when the landowner object, the landowner can object only on the ground that it is not required for public purpose. Other than that,
Other than
they
there
can
is, on the aspect of compensation, he has all the rights, but
yes,
to resist acquisition, it's very difficult.
they cannot. My lord, they cannot.
Difficult.
My only submission is, my lord, in terms of Section 12, award has been passed, award has become final. Now, if the petitioner is interested in enhancement of the compensation on the ground that he did not get opportunity to place his material. That is his ground, my lord. That can be done before the district judge, reference court. Same relief you will get because reference court under section 18, the same power has been given. Lordship will just see one judgment I'm saying. This is the judgment rendered by division bench of this honorable court, my lord, on 29th of November 2024.
Recent judgment.
Yes, 29 November 2024 by Honorable Justice T. Barua and M.K. Kalita. Not reported in our journal.
It doesn't matter. Please
Madam,
give the
yes.
judge.
In writ appeal number, there are several writ appeals. Writ appeal number 5 of 2021, Lordship may say.
First case, leading
My
case.
first case here.
Judgment dated?
Judgment dated 29/11/2024.
Okay.
Parties are minor State of Mizoram versus S.H. Tarkunga.
Okay.
Para 84 in the reporting in Supreme today. There is a citation for Supreme today 2024 0 Supreme Party 166.
One six
36. 2024 0 Supreme Guwahati 1636. Para 84 Lord Mekati.
Yes.
Para 84 please my. Okay. Section 12 of the Act of 1894 is very pertinent for the present dispute in as much as in terms with Section 12(1) of the Act of 1894, when such award is filed in the collector's office and they even accept as provided in other provisions of the Act of 1894, it shall be final and conclusive evidence as between the collector and the person interested whether they have respectively appeared before the collector or not. He says he didn't appear. In respect to the true area, the land, so the value of the land and the apportionment of compensation among the persons interested. The finality attached by Section 12 of the Act of 1894 also binds the appropriate government as the collector had performed his duties as an agent of the appropriate government. Now, my lord, para 86 is important. At this stage, this court finds it very pertinent to take note of a judgment of the Supreme Court in the case of Naresh Kumar versus and others versus Government of NCT of Delhi, reported in 2019, Volume 9, SCC 416, wherein the Supreme Court dealt with the interplay between Section 11, 12, and 13A of the Act of 1894. Paragraph 8 to 12 of the state judgment being relevant are reproduced herein under. There is no provision under the Land Acquisition Act of 1894 for review of the award once passed under Section 11 of the Act and had attained finality. The only provision is for correction of clerical errors in award, which is provided for under Section 13A of the Act, which was inserted with effect from 24/9/1984. The relevant section of 13A of the Act is present. Now, my lord, the next paragraph. Yes, para 88. In the foregoing paragraphs of the instant judgment, we had taken note of Section 12 of the 1894, which stipulates that the award so filed in the collector's office shall be final except as provided in the other sections of the Act of 1894. The reference to the other sections pertains to modifications made to the award by the reference court or by the High Court is subject to Section 21 and Section 25 of the Act of 1894. This aspect of the matter is clear from the judgment of Supreme Court rendered in the case of Sharda Devi versus State of Bihar and another reported in 2003, 3SC 128. Paragraph 34 of the state judgment being relevant is quoted herein below. The award made by the collector is final and conclusive as between the collector and the persons interested, whether they have appeared before the collector or not on two issues. As to true area, there is a measurement of land acquired. As to the value of the land, that is the amount of compensation, and as to the apportionment of the compensation among the persons interested. Again, between the collector and the persons interested, and not as against the persons interested inter se. In the event of a reference having been sought 74 under section 18, the collector's award on these issues, if varied by the civil court, shall stand suspended, superseded to that extent. The scheme of the act does not attach similar finality to the award of the collector on the issue as to the person to whom compensation is payable, in spite of the award by the collector, and even on failure to seek reference, such issue has been left available to be adjudicated by any competent court. So these being the position, my lord, if the award becomes final, only review is only in respect of the clerical error.
Arithmetic.
Then, my lord, section 11, lordship, kindly see section 18. What is the power of the reference court? Lordship court, my lord, section 8. Any person interested who has not accepted the award may, by written application to the collector, require that the matter be referred by the collector for the determination of the court, whether his objection be to the measurement of the land, the amount of compensation, the persons to whom it is payable, or the apportionment of the compensation among the persons interested. Every aspect of the matter can be dealt with by the reference court. Entire thing is open. So if my learned friend is saying that for not giving adequate publication under section 4, or objection under section 5A, or any other claims and objections under section 11, etc., my lord, then he can raise all the objections before the reference court, and he is entitled to, he is interested only in the fair compensation. Fair, he will get. My submission will be, my lord, lastly, my learned friend is saying
On the aspect of limitation, which
my
Mr.
lord,
Kejriwal
I'm
is.
coming, that is why on this aspect, my lord, my submission will be, while section 18 makes a provision for limitation of 6 months, etc., my lord, the provision which is there in section 12 is my lord, mandatory in nature. Once it is passed by him, it becomes final. Now, for enhancement, etc., if they do not accept on the ground that it has to be enhanced because I did not get the objection. Because my learned friend's client will not be interested in objection if it is not for enhancement. Other than enhancement, he cannot have any other contention. So that being the position, my lord, enhancement power has been given to the reference court under section 18. And lordship is exercising power under article 226, my lord. Your lordship will not be, my lord, bound by the provisions of limitation. Your lordship has often done it, my lord. But no, because of this provision, I am giving the liberty to approach that.
And writ is pending since
Yes,
13.
ma'am. And my lord, one more thing. The award was passed, if assuming my learned friend's contention is correct, that award in some of the cases was passed during the pendency of the writ petition. If you are interested in enhancement on the ground that I did not get the opportunity, immediately thereafter, you, by way of an affidavit, it was brought to your notice. Immediately within the period prescribed, you should have approached the collector for making a reference to the
Reference court.
Yes, madam. That he has paid. It was incumbent upon the petitioner to immediately say that I did not get the award. You have passed the award now. Now within 6 months, doctor will kindly give them a liberty. We will approach. That he has not done.
Brought on record in 2017, my lord.
All right,
And awards have been made in 2012 and 13.
I'm talking after
So
that.
6 weeks left, my lord.
If my learned friend says that the proceedings have left under these of some of the provisions of the act, and please don't initiate any proceedings, their matter would have been different. He doesn't want the land back. If he says that no, I want my land back, he's not saying that. He's saying in the alternative, kindly calculate the compensation because under 2013 Act, because
No,
he's-
that is from the relief claim.
Yes.
That becomes apparent that the
yes, ma'am. That is why
the
I'm
demand for getting the land back is not
Not
that
the-
much. He is
yeah.
not, but
That
we are,
being the
but
position,
at
my
the
lord.
same time,
Yeah.
we are concerned of the rights of the petitioner.
Absolutely, ma'am.
He should not be. He should be treated fairly.
Yes.
And whatever his entitlement, it should be given to him.
Yes,
That
ma'am.
is our concern.
Let me lord, my learned friend is saying that there is no prayer for restoration. Your lordship may kindly see. I
No,
have,
no, we have seen, but
I have asked for restoration, my lord.
no,
If there
that
is
is,
violation of-
but let us look it from a practical point of view.
My lord.
Mr. Kejriwal, please answer the question directly, okay? We have, let us assume that we have accepted your, not assume. In fact, it appears that the mandatory requirements have not been followed. But there is an award which is on record. You want an award to be freshly done by giving you an opportunity to place your case while the assessment has been made. Now, what difference will it make, or what prejudice will it suffer if that stage is at the reference court? Just think over.
My lord,
We don't want you
Your
to
lord-
suffer a prejudice.
yes, my lord.
What the endeavor which will make before the collector to pass an award, which by taking into consideration all the relevant factors, what difference will it make in that endeavor being made by the reference court?
My lord, the reference court can look into only two things. If the award is passed after giving an opportunity of hearing by placing my evidences, the past should be read,
Yes,
rate of the land, etc., my lord,
yes,
and the same were not considered,
yes.
then I will place those things before the collector.
No, for enhancement, you can place all your evidence. There is
But
no
the
restriction.
legality and validity he cannot decide.
No, legality and validity.
Similarly, the reference
Legality and
court,
validity will not even go. We'll assume that it is legal valid. But you have not been, your scope of to place your case before the collector, you have been deprived of that scope. Now the entire thing will be looked into by the reference court. It will shorten the litigation. Otherwise,
first the requirement, if the award is nullity, my lord, if the award passed by is violative of the provisions, my lord. 2024 has said, my lord, 2024.
we
Supreme-
are not going on those.
The
If
court
we
has
go,
said-
if we go to that line, there will be an unending process.
My lord, I am-
Land has become now in such a condition that it, even if it is reverted back to you, you can do nothing. The drilling has taken place
Yeah.
2013 onwards. But we are concerned that that a fair compensation has to be given to you, whether you have received it or not.
Let him pass a fresh award, my lord. A collector to pass fresh award, thereafter I will approach the reference court only.
I think we'll do one thing, Mr. We'll have this matter after the vacation, but only on this issue.
Only on.
Because Mr. Kejriwal, maybe he's rightly pointed out the aspect of limitation. Writ court, yes. But at the same time, we cannot forget that the award, so-called whatever, is passed during the pendency of these cases. And
Correct.
when this court is in session, whether 18(2) will strictly come into effect or not.
That is one
And-
part, my lord, and we are faced with the situation where 18 says there is a limitation, and second pure.
And
case
the
is
second
final.
is a question which I just posed to Mr. Kejriwal. The opportunity of placing his case before the collector, before passing an award, and placing it before the district judge as a reference court, will it make any difference?
Yes.
If it doesn't make any difference, you can also take instructions.
yes.
And rest assured that if we make an order to approach the reference court, then we will leave it everything open.
Yes.
Everything has to be seen because you are not even given the chance to place your case. What would be the rate of the plot of land? What are the contemporaneous
Market.
materials? Whether the factors in 23, I think. 23.
My lord.
Was it 23?
Yes, my lord.
23, all
20.
were there factors taken into consideration?
Yeah.
The size of the plot, the vicinity,
Every
all those things.
market value of the land.
Market value, everything. We have this for further hearing. When? 22nd July.
But we'll make it parted so that
No, we want to finish this off, actually. We wanted to finish this off. No. Heard 3 SK Kejriwal Learned Council for the petitioner. Also heard 3 D Mazumdar Learned Additional AG Assam, assisted by your name? DDV. para. This writ petition is pending since the year 2013. And the learned counsel have addressed this court at some length. Full stop. List again on 22nd of July, 2025 for hearing.
Maybe kept as part heard.
We have already indicated. That compilation, I think you should take it back and give it on the next date. He should get 5 additional marks for neatness.
My lord.
5 marks for neatness.
Exact.
See the compilation? See the page marks.
But 1 mark he will get less because in my compilation there is no page.
Because you do not give marks.
Milord, I am supplying the copy, he is not supplying the notes.
See how he has marked the pages.
With pencil pen.
Not pencil. See it.
He's giving a different picture to your lordship and different picture to me. It is not.
See, touch it, fill the page numbers. It's a different page. He has pasted.
It is like embossing, man.
Embossing. It should not give an idea that he has a weak case.
No. Never. That is why, man. I'm very careful.
No, he may be having a weak case, so he's concentrating more on the presentation.
Lord will decide better on it.
How like it?
আৰু কেইটা আছে আনলিষ্টেডটো কৰি দিম ফাৰ্ষ্ট হিয়াৰিং আৰু বেছি ল'ব নোৱাৰিম মোৰ মিটিং আছে আৰু
Right, please. But in this matter, basically, the issue is with regard to demarcation of a particular plot of land to which the petitioner has been holding since the last 50 years. Because his ancestral land. What has happened, your lordship? Basically, we are challenging on 3 grounds. One is that an appeal has been filed and the appeal was still pending. There's no order on appeal. Number 2, your lordship, the notices have not been given to the concerned person. And thirdly,
you're related.
All are related persons. They are relatives. Be honestly speaking, some of them are also, your lordship, lawyers of this honorable court. So, anyways, I am basically, your lordship, what has happened? Lordship, there was an order by this honorable court. In that order, that is at page 26. I'll straight away take your lordship to that order. Page 26, annexure 3. There was a direction by this honorable court, but in that case, the petitioner was not even made a party. That at page 26.
Now, what is your claim? What do you seek here?
No, only thing, your lordship, as per the rules that I have also annexed, that your lordship will find at page 31. I'll just point out only one. Page 31. There has
but his appeal is pending, madam. When the appeal is pending, if you take some action, appeal will become infructuous.
Appeal, your lordship, was filed on 16/5. That is 16/6.
16/6 appeal was
filed, and then thereafter, and in fact, your lordship will
And the
kindly see
notice is
the
that what is the notice?
demarcation letter, your lordship, that they have not even given a date there. It's -6/2/2025, not even the date. And it was served yesterday, and today we have filed this, and they have fixed it within 2 days, your lord.
Now, what demarcation, if it is done, what prejudice will you suffer immediately?
Your lordship, what has happened, this land is in the possession of this. Now they have stated in the writ petition which was filed earlier that they have already bought that plot of land. Once a certificate is issued by the your lordship Black Mandal with regard to the
Would it be done?
demarcation, then your lordship the issues happen. So what my simple prayer is that let them finally I'm not against the demarcation. Issue the notice to the parties who are, your lordship, who will be the sufferers, if at all, because there are some cases within the boundary between the parties. Civil matters are going. And secondly, if your lordship, without going into all this, there has to be a Lat Mandal's report on that. The report has also not been filed.
Madam, you take instructions.
In fact, my lord, on verbal instruction, my lord, that as you civil has informed me that report has already been submitted to him by the Lat Mandal, my lord. And accordingly, in exercise, in the direction, in compliance of the direction in earlier writ petition, my lord, that exercise is being carried out for demarcation. And for that purpose, notice has earlier issued on 29. Next notice.
Now, what about the appeal preferred by
Appeal,
181?
that co-district commissioner, I have to take instruction.
That is what we are interested in. Okay. We'll have this
Because
one.
otherwise, if that exercise is.
We'll have this on
carried-
Friday. Okay, don't take action. Okay. Third, Sri Y.S. Mannan, learned counsel for the petitioner who has moved this petition. Out of turn by means of a mention memo. Para. It is the case of the petitioner that an exercise of demarcation was scheduled, which was preceded by certain litigations. And against the same, the petitioner had filed an appeal under Section 8 within bracket 1 of the Assam Right to Public Services Act 2012 on 16/6/2025. Full stop. However, during the pendency of the appeal, however, even before the said appeal was considered, another notice has been served upon the petitioner yesterday, which does not bear a clear date. Full stop. Para. Let it has been contended, and the learned counsel has submitted by the said notice, submitted that by the said notice, the date has been fixed for demarcation tomorrow. Tomorrow. Para. Considering the above, this court directs Ms. M. Borman, the London State Council, to obtain instructions, more particularly with regard to the FATE of the appeal said to have been filed by the petitioner on 16/6/2025. Let this matter be listed for motion on Friday.
Right.
Till the next date, status quo as on today be maintained.
Of late.
Much.
We'll try to give you the order.
My lord.
We'll get the order this evening itself. We'll get it uploaded.
Obliged.
Item 22.
May it be the lord.
Yes.
Madam, this is a matter relating to payment and compensation of land equity. On land allotted matter far back in 1996, without making any payment of compensation.
Yes, Mr. Tudor.
APGCL,
APGCL. Yes,
Assam Power
APGCL.
Generation Corporation.
But what is your stand? What is their stand? Land has been acquired by,
Land has been allotted.
Allotted and they constructed a.
allotted to APGCL.
APGCL, my lord.
It was the
The
petition.
petition was that, my lord, main issue is that pattas were issued subsequently after allotment of the land. So that is the
Okay.
point, and the allotment order itself says that they have to pay the compensation to the project affected tenant. So what is the amount required to be paid?
Nothing has been paid till now.
No.
Who will have this? Where's Mr. Nath? Yes, are you appearing, Mr. Das? Okay, we'll have it immediately after the vacation. Okay. While Ms. P. Burman, learned counsel for the petitioners, is present, comma, a prayer for adjournment has been made on behalf of Sri G. Nath, who appears for the AGCL, APGCL. APGCL, huh? Also heard Sri J. Chutia, learned standing counsel, KAC. And for revenue, anyone? G. Hazarika? And Ms. G. Hazarika, learned standing counsel, Revenue Department. Para, in the interest of justice, matter is adjourned to be listed on 24th of July, Thursday. Yes, all matters. What are these?
Okay, here is very small. Yet they have challenge one clarification is to the State Department that he is required to pay the floating and unloading charge. That clarification at page 79 has been put on the.
Not been decided this matter.
No,
Similar cases were, I think, there.
no, if this type of matter has not been decided by any high court.
Yes, madam.
Your Lordship, my senior is on legs on another court.
Who is your senior?
And Haveli, Your Lordship. Your Lordship, matter may be passed over for.
But as any has to tip permanent arrangement.
What is the small issue? How long will it take?
No, I'll read out my affidavit. Here they are.
We'll have it day after tomorrow then. Day after tomorrow, okay, madam? Okay.
Lordship, can it be after?
Why? Day after tomorrow we'll try. There'll be no much, motion matters will be very less. A prayer for adjournment has been made on behalf of Miss Anne Haveli, learned counsel for the petitioner. Puts up 3SC Kyle, learned. You act as what?
I'm by senior standing counsel, DST.
Senior standing counsel, CGST is present, para. List for hearing on Thursday, day after tomorrow. 26. 26.
In this case, on the last occasion, there is 21st of January. An order was passed to collect the relevant
Yes.
this court consequence to permitted HK.
Here case 1216.
Yes.
Yes.
Now, my learned is appearing on behalf of Mr. Das, my lord. Possibly he has received the record.
You've got the records?
Yes.
Yes.
Sometime it's done.
What is the matter?
This matter, your lordship will remember, this is regarding the bank robbery at the UCO
So
Bank.
that entire case record.
Yes, yes, and the CD had gone missing. my lord.
Now it has been reconstructed or what?
No, my lord.
For the purpose of ascertaining whether any CD was a duplicate or
But one, I think Justice Surana had passed an elaborate order in this, if you remember
Yes, yes.
correctly.
Regarding that maintenance of 3 case diaries,
Yes.
the report had been submitted in the meantime, saying that no second and third case diary is available in the case.
Okay, then we'll have it this after the vacation, okay?
let
this matter come up after.
Okay, okay. Heard Sri D. Goswami, learned counsel for the petitioner. Also heard Sri D. Mazumdar, learned AAG Assam. Ms. D. Mohanto, learned counsel, appearing on instruction of Sri H.K. Das.
HK Das.
Standing Counsel High Court has submitted that in terms of the order dated 21/1/2025, comma, the records of the ZR case and copies of the documents pertaining to GR case number 1216/1985 have been
Order
furnished.
sheet-
This is the
order sheet
only.
here.
Huh?
Order sheet, order sheet.
Order sheet of
Order
the,
sheet of the GR here.
record here, it is taken records of the order sheet of the
Here case
Oh,
number
order-
1216.
1216
No, 1985.
1985 have been furnished to, have been recently furnished, para. In view of the above, the hearing of this matter is deferred. Deferred, list after notifications.
Kindly fix the date so that
uh,
23rd.
As
Right.
requested, list on 29th, Tuesday, okay?
29th of July, madam.
29th, yes.
Thank you.
Lordship, I apologize. Earlier matter I had appeared wrongly, night of it, but it was a
Should not be
mistake.
too serious, it matters.
I apologize.